Preventive detention. My lord had directed on the last petition, that is on 28th of April, for the matter to be listed within the top 5 matters in yesterday's list. However, the matter was listed as item number 96. Today, item number 94. It's of extreme importance to the life and liberty of women.
With your lordship's kind leave, my lord,
Give whatever the mentioning you want, hearing, urgent hearing, give all the list to my court office.
my lord,
Yes, give all urgent hearing, give.
My lord, we're trying to find afresh, my lord.
Give all the urgent hearing. Give all the urgent hearing. Call the list.
My lord, may I?
my lord, item
Just
number,
one second.
Call the list.
My lord,
my lord, item number 107 from your lordship's today's list, my lord.
My lord,
Your
only
lordship has
one
given me liberty, my lord. Your lordship has
my lord,
given
one
me liberty.
matter, your lordship
Travel
knows, my lord, it
application.
is fixed today. Your lordship knows that designation of senior. Now, my lord, we have come to know your lordship will not be available from Monday. My lord, if your lordship can fix a date, my lord, we have served notice to all these.
Which matter?
My lord,
It cannot be taken today.
107,
no,
my lord.
that is why, my lord,
Ah,
because it will not be taken and your lordship will not be available.
ah,
From Monday, we have come to know.
ah.
Only praying that if your lordship can fix a date,
Fix a date.
my lord, maybe after vacation, because your lordship will be.
Which matter?
My lord,
My lord,
I'll just tell.
my lord, item number 107, your lordship had given me leave for travel application, your lordship. It will take only 5 minutes, my lord. The matter is listed, but it's, my lord, may I give notice
Try
to
your luck. If it is listed, it will be taken. Otherwise, Monday move before the appropriate court.
my lord,
All
may I-
matter cannot be taken
my
as
lord,
urgent
your
matter.
lordship
Yes,
had
call the
passed earlier order, my lord.
My lord, item number 1, I appear for the petitioner.
Pass on the slip. Who is for the petitioner?
My lord, I appear for the petitioner.
Who is for the respondent?
My lord, I don't see any.
The writ petition is disposed of with certain directions.
Grateful, my lord.
I appear for the
Report two.
I appear for the petitioner, my lord.
Item
The
number 3.
3, my lord.
Ah.
My lord was pleased to pass an interim order, my lord, which appears at page 8, my lord.
Hmm.
And the same has been extended from time to time.
Hmm.
The last extension, my lord, will find, my lord, at page 23, my lord.
May 8. Yes, then
Lord, this is an application, my lord, for extension.
which for
of
the
in-
other side?
I'm for the respondent.
Yes.
Lord, the affidavit of service.
ये
my lord.
एट टू बी मेंशन क्यों आया? तुम लोग ऑर्डर नहीं पढ़ते? मई 8 को जब 20 मैटर में रखो बोलो, मेंशन में क्यों आया? सीधे लास्ट ऑर्डर 24th अप्रैल. They have mentioned. They have mentioned. There is a mentioning list. I will vacate the order. If they have mentioned the matter for extension of interim order, fixing the matter to be mentioned in spite of having the knowledge that the matter is fixed today as item number 20, then I will vacate the order. If you have mentioned the matter after knowing that the matter is fixed, especially today, whose sign is this?
My lord.
I am vacating the order herein now.
Your lordship would kindly, my lord.
I am vacating the order herein now.
Kindly, my lord.
Who has mentioned this?
No.
My lord, this is key mention position.
Yes, give that. Record an order. It is an unfortunate affairs on behalf of the counsel for the petitioner. It is an unfortunate affairs on behalf of the counsel for the petitioner. Knowing that this court has specifically fixed the matter within 20 matters on 8th of May 2026. An interim order is also extended till 8th of May 2026. Only to mislead this court, the learned advocate on the learned counsel for the petitioner has mentioned the matter on
Lord, your
7th of
lordship
May
would-
2025, be giving an impression upon the court that they will pray for extension of interim order. Accordingly, as per the mentioning list, this court has fixed the matter as to be mentioned. when the matter is taken up for hearing, it is found that today already the matter is fixed at item number 20, but very intelligently learned counsel for the petitioner wanted to heard the only for extension of time, mention the matter for extension. Accordingly, this court find that
My
the
lord,
petitioner is
your
not
lordship would-
entitled to get any interim order
My lordship-
extended. The interim order is
Your
not
lordship would
extended
kindly,
and
my lord.
vacated.
Your
Next.
lordship,
Call the matter.
No, I can move for appeal for the respondent 6.
रिमेन का वो तो आज था उन लोग मेंशनिंग में लिखेगा नहीं तो जब जाएगा जाएगा.
Milord, the matter has been kept today, Milord, only for a
Yes, yes.
very short purpose. But I think, Milord, Mr. Bose was not properly instructed by his client. Please have a look to page 124. But the point is, Milord, whether, Milord, the chartered accountants, Milord, they were certified or, Milord, registered by the Institute of Chartered Accountants.
Yes.
Milord, Mr. Bose's submission was, of course, Milord, pursuant to his client's advice or instructions, that, Milord, this certificate was effective from 30th of August 2023. And the chartered accountants, Milord, they had certified in 2022. Therefore, they were not authorized as on that date. Now, Milord, please look into this certificate. We are not experts. That's why, Milord, I couldn't, Milord, answer on spot. But may I read it in its entirety? The Institute of Chartered Accountants, peer review board, peer review certificate number, etc. This is to certify that peer review of Messrs. Such and such, then there has been, the address is there, has been carried out for the period 2020 to 2023. Pursuant to peer review guidelines issued by the council, so and so, this certificate is effective from 30th of August 2023. This certificate will remain valid to 31/8/2026. Therefore, Milord, this chartered accountant, Milord, he was registered, Milord, with effect from 2020. This is only a renewal of the existing certificate as I was submitting, Milord, on the last occasion. Milord, your lordship was pleased to. Yes. But for example, Milord, your lordship may have a look to this, Milord. But in fact, Milord, they were, Milord, certified from 2016.
May I have, my lord, something which was handed over? If I have a copy of what
No,
was
not
handed
required,
over.
Milord, just only to show that it's from 2016. Now we are concerned about 2022. Let us not go to history. Just for the purpose of showing the court. Right, with respect to a waste of judicial time, Milord.
Yes.
That means after the matter is
So as per this, the first document is
of
first
of
April
2016.
2013 to 16
Yes,
and issued on 17.
yes.
Next date of review was 2020.
Then 20.
Has been carried out for period 2020 to 2023.
Right.
Then it was extended for 23 to 26.
Yes.
Yes, Mr. Bose.
Then we are page 121. But I have so far as the other person is concerned, that is at page 125. Again, Milord, your lordship would find the same thing.
Yes.
Message S. Malik, 2020 to 2023.
Yes.
But the other thing, Milord, just Milord, for the sake of clarification, just kindly have a look at this. But the other point was that we were to refund or return with compound interest. That was the submission. Now, please, Milord, if your lordship may kindly come back to page 79 once more. So this is the certificate which, Milord, the submission was made that they were not authorized on that particular day.
Yes.
Now, please take note, page 79, the table at the bottom of that page.
Yes.
But I'll read, Milord, the column headings. First is particular. Next is number of depositors. Then total amount of deposits received and settled is 14 crore 75. Then the next one, total amounts of half yearly compounded interest payable is 4 crore 43. That was another point we had raised. So this is quantified on compound basis. Milord, the interest payable was 4.43. Then the next column is applicable interest for investors paid through bank is 3.12 crore. Applicable interest for the investors paid by cash is 1.30. So the matter should end over there. But still, Milord, I have Milord submitted before your Lordship's Milord on the last occasion or on the first occasion that Milord 1 crore is lying with them. It has accrued interest. Milord, they have Milord attached 3 crores and odd in excess, which my learned friend appearing for the State Bank of India had submitted. Milord, please put me to any terms even thereafter to secure the interest part, if at all there is something due. And Milord, kindly allow us to operate the accounts. Milord, I cannot be kept hanging, or my business cannot remain stopped for decades.
As per them, 1 crore 80 lakhs, 16,500 is recoverable.
Yes.
As per their report.
Yes, what they are saying there is no basis, but let us proceed on the basis.
Correct.
Milord, because I will not, Milord, at the interim stage, Milord, invite the court into go into all these things.
Correct.
Milord, your Lordship puts me into any terms. 130 is with them.
130 already paid.
Yes.
As per this certificate.
Plus 1 crore, Milord, in excess, Milord, is lying with them. That your Lordship would find, Milord. Well, look into the this order. Please have a look toward page 75.
Yes, 1 crore is with the CB.
Yes.
1 crore.
Your Lordship has marked it, Milord, on the first occasion.
1 crore is CB.
Yes. Therefore, what remains, Milord? Kindly, Milord, stay, Milord, the attachment orders, Milord. Let me carry on with my business, and then, Milord, your Lordship may decide the matter finally. And look into the report which has been filed. What is the last line of the report?
That's why they are asking that 1 crore 80 something is recoverable.
No. Recovered.
That is
Proceeding
recovered.
currently underway.
Has
yes.
been
And has been
recovered.
recovered.
This-
Yes.
About 1 crore korte geche.
Recovered, already recovered.
Yes. And Milord, the entire report does not say what is due and payable.
এটাই তোমরা ভুল করেছো। 45 crores
Let us proceed on the basis that 1.84 is payable, 1.80. The last paragraph of the report, para 29, page 13.
Yes.
1.3.
They have only stated that 1 crore 80 has been recovered.
Yes. Now,
So,
there's
and
no
as,
basis.
as per your case, you have deposited this much amount, that is 1 crore 30,
Yes.
and 1 crore is already lying there in terms of
Yes.
this order.
Yes, yes. But if required, Milord, without going into Milord any dispute, the balance amount, Milord, I'll deposit, Milord, wherever your Lordship directs, so that Milord, I can operate my accounts.
Yes.
বলবো?
Hello.
My lord, a cheat fund company says that it's a waste of judicial time. My lord, I'll show your lordship this litigation is a waste of judicial time. My lord, who admits violation of law, my lord, kindly come back to page 124.
Now, first of all, with regard to the certificate.
Correct, 124. Kindly come to 124.
Correct.
I respectfully disagree with the interpretation of the certificate. What did your lordship say the other day? If you have a certificate, bring it. Matter ends. So far as your principal amount, which has been certified by the two chartered accountant in 2022, that part will get covered if they were certified at that relevant date. Now, my lord, kindly have a look at the certificate. My lord, kindly see the middle portion. What does it say? The peer certificate, this is to certify that the peer review of such and such has been carried out for the period 2022 to 2023. So in order to give you the certificate, the authority, which is the Institute of Chartered Accountant, they has to examine whether you do any proper work or not. So the period which is examined is 3 years. This is the regulation provides 3 years. So they ascertain whether they do work for 3 years, and then what do they do? Has been carried out for the period 2020 to 2023 pursuant to the peer review guidelines. Your Lordship, kindly make a note of this. Issued by the Council of the Institute of Chartered Accountants of India. This certificate is effective. Now, my lord, kindly look at the preposition used. From
Correct,
and then till.
correct.
So from and till makes it what? So that means this certificate became effective
Yes,
from 30th August 23 and would cease on 31st of August 2026. Say, for example, kindly take this situation, illustration. Suppose on 1st of September 2026, they do something as a certified. Would that be valid? So the validity was for period of 3 years. So there must have been a certificate prior to 23. So the certificate is issued.
You got the copy?
Yes,
That is what
Have you got the copy?
that is what they were supposed to show, your lordship.
Have you got the copy?
No, I have not. They have not given it to
Kindly
me.
come to the first document.
First,
First document,
First
I get third document. The first I issue.
First.
this one.
Yes,
Well, this one.
yes.
Yes.
So this is also
Yes.
has been carried out for the period 2013 and 2016. Pursuant to the statement issued at New
No, my
Delhi.
lord, the first page that I have,
Third page, correct.
third page, sorry, my lord. Third page, yes, my lord. 13 to 16,
Yes,
yes, my lord.
correct.
Yes,
And pursuant to the statement, so issued on 17.
yes.
And next date of the review is 2020.
2020,
Correct.
right?
Next date of review 2020.
Yes.
Their contention is that this certificate now review has taken on 2020 to 2023
Yes.
and issued that continuous and again issued the certificate on 30th
Yeah.
August 2023. So what is your answer on that?
No, my lord, my answer is very simple. If your lordship kindly comes to the third page,
Yes.
it says it has been carried out for the period. Your lordship will see 3 years again, 13 to 16.
Correct.
When it gave 13 to 16, it gave it from 17.
Correct.
Now the question is that whether in 2020, question is not 20. So even if your lordship takes the certificate is 17, it's end in 20.
Correct.
Why does it refer to 20? Because the 3-year period from 17 to 20 expired. So in 20 to 23, this is the relevant period for your lordship's consideration. Where is that certificate? So if they don't have that certificate, the 2022 certificate is wrong. Well, number one. Number two. So, my lord, the certificate, what they are saying, so they don't have that certificate unless they produce that certificate. And, my lord, if your lordship will see, page 59 of the report, this is an unequivocal admission by the writ petitioner.
Yes.
Now they are trying to, my lord, they are now trying to
59?
say, yes, my lord, 59.
59
If they had this certificate, then this question would not. Kindly see the submission of the authorized representative, the noticee, which is the writ petitioner here.
Yes.
So if this is the situation, so then why did they make this statement? Then they should have said what?
Yes.
In 2022, they had the certificate. So this is inconsistent with what they are saying now. Now, so far as interest and your lordship has been inquiring, and Mr. Dotto has been taking advantage of the report and the language given in the report. It does not say how much is due. I'll show your lordship how much is due. Kindly have a look at this document. This is what is due. 45 crores, 58 lakhs. This is what is due.
So this is only a chart.
No, so
That
you have
is
given so many charts, so I haven't said anything.
No,
This is
it's
a
not
chart.
it's
Chart
a
prepared by
certificate.
whom? I am not any third party on the roadside. I am SEBI. So if I am giving a chart to court, so there is some responsibilities the officers have undertaken to give this chart to the court.
No, recoverable amount 1561.
Yes. Interest, kindly, my lord, kindly have a look at the interest component. Your lordship, for the time being, your lordship may ignore the first recoverable component of 15 crores, which was the principal.
Correct.
Kindly have a look at D, serial number D.
Where your report says, where your report says this figure.
No, that is the mistake that we made. So they should have said that the report, if it is prepared, this is what happens when a report is prepared by the department and not by the lawyers. So they should have taken our assistance in preparing this. So now, my lord, what we are saying is,
No,
The-
in that case,
Yes.
suppose, in that case, then if we come to your order, come to the order,
yes, my lord.
page 65, 63, page 63E. First page 62, 33A
Right.
and
So it's criminal order, sir.
63E. These are the
Yes, my lord.
two things is to be completed. Now, after that, then you come to page 75.
My lord.
Out of 15.6 crore, out of rupees 15.61 crore, character Mr. So one of the director of company has deposited an amount of is 1 crore. So 15 out of 15 crore. So your claim is kindly
My lord, your lordship is looking at page
75.
75. Notice of attachment.
Yes.
Yes,
This
my
is
lord.
notice of attachment.
Yes.
So it is in as per your notice of attachment, 15.61 crore was the total amount which you are now
The principal. Yes.
correct. Mr.
Yes.
Rajesh Jaswal, one of the director company has deposited amount 1
Yes.
with the SEBI. So that has been deposited. So that is the second column of your the document which are now given.
Yes.
Correct. Now,
My lord, kindly see the date of the notice also, my lord.
hmm,
This notice was of 2020.
20.
Yes.
20.
6 years.
Correct.
So the
20.
interest of 6 years compounded
let-
half
let-
yearly.
let-
Yes,
let-
very
Okay. Then the certificates come.
my lord.
Then the certificates come.
Comes.
As per the certificate, they have stated that 1580. Now come to the
My lord,
77.
certificate, if I may once again repeat, my lord, is non-est in the eye of law.
No,
So
if
their certificate doesn't deserve consideration.
as per your case, they have not deposited any amount other than 1 crore.
Nothing. As unless it is certified by a proper, which they are, if they, like lordship kindly appreciate that, if today they have actually paid, why can't they get it certified once again? Today, these two chartered accountants
Correct,
they have the appropriate certificate till
correct.
August 2026.
Correct.
So why are they not doing it?
Okay.
They can undertake the same exercise once again and give the certificate, the same to chartered accountants.
Okay.
If they have given it in 2022, why are they not giving it now? Why are they shying away from giving this certificate once again on that 15.6? So interest will be a different issue altogether. But the principle they have said in the 2022 certificate
But with
that it has
respect,
been
to
paid.
Mr.
Then
My
you
lord.
come to your calculation.
My lord, my calculation.
Yes, just
Yes.
today we are given.
Yes, my lord.
So that
You can spare one copy.
Yeah, I'll give you one.
E
Yes,
is
my lord.
the total outstanding.
Yes, my lord.
E equal to A minus B minus C.
No, A minus, no, my lord. These are all.
A minus B minus C.
Yes.
So A minus means 50 crore is to be minus.
No, 15 crore now. A minus B.
Correct.
A is 15 minus 1.
Okay, minus B. So
Minus B minus C
170
plus D.
plus.
So A is the principal minus 1.
Now the 1561 and 3276.
Yes.
These are the two you have.
And minus 1561 plus 3276 minus 1 minus 1.79. That
Correct.
means
So
2
we-
crore
we-
79.
We directly will go. Then
Yes.
1561 plus 3276. These are the two plus.
Correct.
And it's B and C are the minus.
Minus.
So now 15 and 32 is to be calculated. That will come as per your calculation 45.
47 crores minus those two. No, if your lordship deducts 1 crore and 1 crore 79.
Directly you come.
Yes, then it comes to 47 crores.
15 and 32, 45.
40. No, my lord, it will come to 47.
So that's why I'm telling how that's how.
No, that's
how
the
it can be.
calculation, my lord. A minus B minus C plus D. So it's like my lord 15 crore. They should have minus 1 crore, which is 14 crore, minus 1.79 crore, that will come to 13 crore. Then 32 crores becomes 45.
Okay. Okay. Yes, Mr. Datto.
My lord, with
Sir,
respect, they are
just a minute.
yes, yes, yes.
Because if come to the first
Certificate.
certificate,
Yes, sir.
17,
Yes,
7th February 2017.
yes,
The next is the next due date for review of 2020.
right.
Where is that certificate?
But that
2022, 2023.
But
it is-
that is, my lord, the continuation which is given very well. My lord, may I, my lord, try to, my lord, address your lordship, my lord, on the quantum first. Please take me at page 102. My lord, how could, my lord, this gentleman prepare this chart? Again, my lord, misleading the court. Please have a look to their document at 102.
Yes.
Please see the first line. Or who is writing this? The recovery ERO, two corporate pleaders, CC is to my client. This has reference to a letter dated, etc., submitting report of repayment certified by two independent post review, peer review chartered accountants on the captioned matter.
Yes.
First line. Second sentence is on perusal, it is observed that cell industries have not paid 15% interest to many investors. There is no allegation that I have not paid the original or actual sum.
That's
What is this certificate? Then Miller Miller, may I just Miller take your lordship through this? Then Miller, Cell Industries Limited, etc., shall forthwith refund the money collected by the company through the issuance of such and such have been found to be issued in contravention of such and such to the investors, including the money collected from so and so till date pending allotment of securities, if any, with interest at the rate of 15%. Now, this was under challenge. Please take note page 104. This was challenged by us before the tribunal. Now, what does the tribunal say? But they have not challenged this order. But there was no dispute in regard to payment of the amount. Now, my lord, please take, my lord, page number
106.
105, paragraph number 3.
Yes.
In this regard, we find that the minutes of the proceeding dated 9th July, the RO has directed the appellant to file a certificate of two independent peer review chartered accountants who are on the panel of a public authority institution with regard to calculation of interest. Based on the minutes of the meeting dated 9th July, a certificate of the chartered accountant was duly filed, which is at page 53 of the appeal paper book, which indicates that a sum of rupees 57 lakhs is payable as interest to the depositors. In view of the aforesaid certificate being filed, it is strange that the RO in the impugned communication is still insisting on payment of interest at the rate of 15%. As per so and so order. Then, my lord, is the final direction, para 5. We accordingly set aside the communication, that this is at 102, and direct the RO to consider the certificate issued by the chartered accountant and proceed from their own and pass a recent and speaking order.
Yeah.
Now they are coming and saying that the certificate is not.
That's why on the last occasion,
Yes.
also, Mr. Datta, I told, okay,
Yes.
where is the 22, 23?
Yes.
The 2020, 2023 certificate is, my lord, reflected from this page itself.
No, because if you realize what the first page,
Yes, my lord.
the review was done in 2017,
Right.
and 2017 to 2020 the certificate was given.
Right.
And next due of the review 6th February 2020.
Yes.
So next date of review is 20. So
Yes.
20, where is the 22, 2023? Because now the certificate which you are relying is 10th October 2023, 26. So 2020 to 2023, where is
Yes.
that certificate?
My lord, my respectful submission, my lord, I have taken instruction. That certificate is not with us, but my lord, at page 125, it is reflected that it has, my lord, his what is called, my lord, his activities where from 2020, 2023, as a peer review chartered accountant was analyzed, and then only, my lord, this certificate is given.
Correct, but 3 years they have taken into consideration.
Yes.
But on that day you have a certificate. You might have been have a certificate, because otherwise why you have written this, the letter which you mentioned, Mr.
Yes, my lord, in the report.
Yes,
in the
that
report.
because they had applied for, kindly look
Yes,
at,
kindly,
Page
kindly.
59.
that letter is dated August, sometimes in August. Can you have a
Page
look to that?
59, page
Ye-
59,
Yes, please say,
August
see,
23,
August 23,
correct,
and please take me at page 125.
22,
No, Milord, this is issued on 3rd of November 2023.
correct. Correct. So
Yes.
review, that's why that review with regard to 23 to 26.
Yes.
With regard to 20 to 23, where is that? That review is 23 to 26.
Milord, your lordship requires the certificate for 2020 to
23.
2023.
Yes.
But Milord, my respectful submission is that was never in dispute.
No, that is the dispute.
No.
Because
Milord,
they-
in August, why this is written? Because in August, Milord, this was before this authority for issuance of a certificate. But
Correct.
we are concerned about a date in 2022
Correct. 2022, you
Right.
have issued the certificate.
certificates.
So you have to prove that on, yes, you are the peer chartered accountant having the certificate on that day.
Right.
Correct.
Right.
You admittedly the certificate you have given 16, 17 to 2020, you are there.
Yes, Milord.
And in the 17th certificate, it reveals that the next review will be taken on February 2020.
Right.
Correct.
Right.
February 20, if the review is taken, then the further certificate will be issued to you 2020 to 2023. Then next review was taken on 23.
Right.
And August 23 to 26, another is there.
Right.
So
Milord.
that's the 20 to 23, where is that certificate?
Milord, may I say this, Milord? Number one, Milord, at page 102, there was no dispute about that certificate.
Which certificate? 102 is of
No.
2021.
102.
No, it's of 13th of January
That's what
2022.
Yeah, so they-
102
My
has been
lord.
set aside by the tribunal.
Correct,
And
yes.
tribunal has again directed the authority to consider the chartered accountant certificate issued by chartered accountant. Now they are coming with the certificate which you have issued, that you are not the peer chartered accountant on that day.
And there is a series of mail
So
which
that-
we've annexed.
Milord, there is no mail saying that your chartered
no, why
accountant.
you are that?
No, my lord, I don't now. I
This
need to say
certificate.
things, my lord. Mr.
I'm
Doctor
sorry.
is
Chartered
possibly
accountant
not aware of
come
the
with
facts.
20 to 23 certificate.
This is this is clear,
Let the
Milord.
chartered accountant file an affidavit. Let the chartered accountant file an affidavit. This is the I had the valid and this is the only certificate which prove that the 20 to 23. This is the certificate. Let the chartered accountant file. I will send to for the inquiry.
Yes, send it to the peer board.
I will send to the inquiry. If
Fair
your
point.
chartered accountant is relying upon this,
Yes.
and I am not satisfied this, let the chartered accountant file an affidavit stating that this is the certificate which proves that he is having the certificate of 2022 to 2023.
Very well.
Let the file, and I will send the certificate to the
Peer board, to the Institute of Chartered Accountants, say that
To,
whether these two chartered accountants have this.
He had the
And your lordship will see the order of the appellate tribunal, which was set aside. What was set aside? What was set aside?
communication.
Yes, no, the minutes of July 21. Then what happened? Then we considered it. That's the order which we have annexed at page 40. Thereafter, since September 2022, the certificates came, which they are today relying upon. So there are about 6 to 8 emails which has been exchanged between the petitioner in 2024, where he has been repeatedly told, give us fresh certificates, that's all. And in any event, my lord,
But I'll take this instruction because I do
You
not know
do one
whether.
thing,
yes.
if he is having the certificate, you file.
Well, it's
Other-
very strange that from 2013 these chartered accountants they had, and in between 3 years they will not have. It's quite
my lord,
strange.
when you take
Well-
public money and you
Exactly,
don't give
but
money
court
back
has
to the
go
investors,
by the document.
Yes.
Court has to go
my
by
lord,
the
your
document.
lordship can aware these are simple common people, lower middle class people with those who invest. This was a scheme, non-redeemable scheme.
Learned counsel for
No,
the
payment
petition
has been made.
filed-
My lord,
Only
may I take your lordship's kind leave, my lord?
Yes.
Great.
has submitted the document
भूलिए छी,
has submitted the document
बोला ले तुम ही
which
बोलছো
reveals
আমার
that the peer review board has issued the certificate to the chartered accountant of the petitioner, namely Messrs. R. S. Ray and Associates, on 7th of February 2017, in which it is mentioned that the next due date of review is 6th February 2020. The petitioner has relied upon the peer review board certificate issued on 11th of October 2023, issued on 3rd of November 2023, wherein it reveals that the certificate shall remain valid till 31st of October 2020, 11th October 2023 to 31st of October 2026. Learned counsel for the petitioner submits that the said certificate itself shows that for issuance of the certificate dated 3rd of November 2023, review board has considered the period of 2020-2023 and thus the chartered accountant, namely Messrs. M.S. Malik and Company, was having the Messrs. R.S. Ray and Associates was having the certificate of valid certificate, peer review certificate from 2020 to 2023. Full stop. Consider the submission made by the counsel for the petitioner. This court is not satisfied whether from 2020 to 2023, whether there is a certificate of the pre-review board in favor of the Messrs. R.S. Ray and Associates and Messrs. Malik and Company. S. Malik and Company. In view of the above, the petitioner is directed to submit the certificate issued by the peer review board, clarifying that the petitioner was having the certificate issued by the review board, which was valid,
Who will have the certificate? Not the
which was valid 2020 to 2023. If the petitioner is not able to produce the certificate, the peer review board, the Messrs. Malik and Company and Messrs. R.S. Ray and Associates, the chartered accountants, shall file their affidavit stating that they were having the certificate, having the valid certificate issued by the peer review board from 2020 to 2023.
But only one instruction I have just now got. So far as S. Malik and Company is concerned, where the person has expired.
Okay. The
Therefore,
company might be there.
that I have to take instruction.
Right, otherwise, fine. Let the documents or the affidavit as stated above be filed within 3 weeks from date. List the matter on 10th of June 2023 within 5 matters. After serving the copy to the land counsel for the respondent. 10th within 5 matters.
Because so far as the
Because SEBI is asking the money and other party says.
So that's why unless and until the court will not decide, you have to
hold the money, enjoy the money.
enjoy the money. Then Mr. Datta's client will ask interest from you. Okay.
Oblige, Your Lordship. I will appeal for respondent number 6.
Yes, do the name.
Oblige, Your Lordship.
Yes.
This millet was mentioned at my instance, millet.
Yes. What is the matter? Who is for the respondent? State.
State.
Very difficult for one.
Very difficult.
So
Lordship will
What
keep it
urgency?
after 2 weeks, millet. In that event, millet, there was some urgency, and in the interregnum period, millet,
I will give the liberty to mention before the appropriate court because next 2 weeks I will not be here.
I would like to do it before your lordship.
Huh?
I would like to do it before your lordship. So
All courts.
I'm very candid in certain things. Lordship knows.
So come on after vacation.
After
then. As none appears on behalf of the state. For the interest of justice, cases adjourned. Let the matter appear on 9th June under the same heading in same position.
Deeply obliged.
Next.
May I file the reply, madam?
It will take time.
No. When Mr. Mitro has come, I'm sure things are sorted out.
Yes. Yes, what is the matter?
This was with regard to non-implementation of a decision taken by the respondent authorities to form a neutral committee.
Acha,
to
that
look
one,
into
that one,
my
yes.
Now, my learned senior friend clients has used a reply wherein paragraph 15 they have fairly said that if my lordship wishes, they are agreeable to form a neutral committee. And rest of the affidavit is explanation. They say that they have misunderstood the order passed in the previous round of litigation. I am not getting into that. When they
So I am setting aside the order and directing the authority to constitute a neutral committee.
there is
and-
already one member in the committee.
No.
And
If it is already there, then
no, one. It was a 3-member committee.
Correct.
One member has already been nominated. If my lord kindly takes me the trouble to have a look at 2 pages.
one advocate is there, no?
Yes.
One senior.
No. My lord, it is nominated by Ministry of Law and Justice.
Where is that?
Kindly, my lord, have a look at page 3201.
203. না দিলে আমাকে কি করে কি
320 is, my lord, in the 3rd volume.
বলেছিস দাঁড়িয়ে আছে
Department. In order
That's
to
the
grant
decision
procedure
taken,
of
my lord, to
five
form a
years
neutral committee.
For engaged in ECA, MOE, procurement, it has been decided to neutral committee with all one member.
Yes. And then
Including one member having experience of the contract law.
kindly take minute paragraph 2. It is therefore requested to kindly suggest a panel of 2-3 persons well versed in field of legal and contract matters along with their fees for inclusion in the committee representing government of India.
Yes.
And then will kindly turn to the next page. Ministry of Law and Justice is nominating one.
Mahendra Khandelwal.
Yes.
One additional government.
Yes.
So they will nominate, they will constitute a neutral
Let they take the decision.
Yes.
If they are continuing with this, it is if they wanted to constitute
Exactly.
a new neutral committee, let they
It has to be a neutral committee.
Committee should be truly neutral. So there should not be anyone from there.
My learned friend's client wanted to go before the neutral committee. I am sure that they wanted to be a neutral and they knew that it was a neutral committee. Otherwise, why should they want to go before them?
We do not know the
So,
composition as of now. So kindly set up it. Kindly direct them to form.
Form a neutral committee. My lord, your lordship can rely upon the paragraph 15 of my affidavit.
Yes.
And I have said that there was a misunderstanding. Well, kindly see the order. Well, just by way of an explanation. I was just looking into the order, my lord, of the dated 12th August 2025, which directed this. There was some amount of confusion was
Yes,
there.
2 paragraphs, there are
Some
there is a discrepancy.
so that is why, my lord, the chief secretary was a bit confused about it. I should not say misled about it, but he was confused.
There are
about
two paragraphs.
two
are there.
paragraphs. So that is why, my lord, it happened. It was totally unintentional.
only with the kind leave of my learned senior Mr. Banerjee I was humbly beseeching if any neutral means the advocate from bar if can be included.
This court is not invoking the power of the authority to the committee,
Exactly.
let the committee.
Because Milad going back to the same person, Milad,
Committee
very
will
well.
be
Neutral committee means neutral committee.
Secretary.
Very well. He should be open-minded. He should be open-minded and accept Milad.
We cannot say the mind of, even I cannot say the what is in your mind. Your
Milad is always open-minded. Milad, nobody can say this, at least Milad. What we have been seeing since 2021, Milad.
You wanted to go to the neutral committee, it will go to the neutral committee.
Yes, yes.
And if you have any misgivings,
And Milad,
come
and
to-
Milad, kindly allow us to be represented by advocates. Sometimes Milad, they don't allow.
The only
No, no, no.
grievance
The
with
neutral committee, it is our discretion.
application
Let
by
it be,
challenging
that
the
discretion be exercised.
order,
You do not impose your discretion on it.
impugn order dated 17/12/2025 by the secretary, to the government of India, Ministry of Consumers Affairs, Food and Public Distribution, Department of Food and Public
Don't take it away,
Distribution,
everything. Don't.
Krishi
You live in a backseat of
that instead of deciding the issue by the neutral committee, the secretary has passed the impugn order. In compliance of the order passed by this court dated 27th of March 2026, the secretary to the government of India has filed an affidavit wherein it is categorically mentioned that in difference to said orders dated 12th August 2025, read with 27th March 2026 of this court, the Department of Food and Public Distribution will constitute a neutral committee, should this honorable court deem it appropriate to do so. Considering the affidavit filed by the secretary, this court set aside the impugn order dated 17th February 2025 with the direction to the ministry. Who will constitute the committee?
My lord,
Who will constitute the committee? Secretary?
secretary. Secretary constitutes the neutral committee. I am sure, my lord, there will be no objection to that.
The respondent number 3 shall constitute to this respondent number 3.
And kindly fix a date.
To
Fix
the
the date.
respondent number 3 to constitute a neutral committee to decide the grievance of the petitioner within a period of 4 weeks.
4 weeks.
Within a period of 4 weeks from the date of receipt of this order. If a neutral committee is constituted.
But kindly make it clear. They will constitute within a certain time and they will take a decision after giving a hearing to
Within
the
4
party.
weeks they will constitute.
Yes.
And if the neutral committee is constituted, the neutral committee shall decide the grievance of the petitioner within a period of 6 weeks thereafter
6 weeks there.
by giving an opportunity of hearing all the concerned
My lord, very good.
parties by passing a reason in a speaking order.
Absolutely.
The petition is disposed.
Very grateful to your lordship.
Grateful to you.
Item number 7, my lord, I get to appear on behalf of the petitioner. I'm led by Mr. Bishuru Bhattacharya, my lord. My lord, the urgency is, my lord, that I have been blacklisted from by the
Which department?
Paschim Bongo Go Sampad, my lord.
State. Animal Recourse Department, Department of West
Yes, my
Bengal.
lord, state had appeared in this matter. My lord, they took time. Initially, my lord, had twofold challenge. One was with regard to the challenge to the termination of the tender, and the second, my lord, was the blacklisting.
You're for the state.
No, it was my leader in the matter. I've never appeared.
Yes, but there no state is there. How?
No, the state, the essential party is is an organization under the state. But if your lordship kindly sees the writ petition once.
What is the payer?
Let's say today, what had happened, I indicate to you. A tender was floated.
in the month of October 2023.
2020?
We had participated in the tender, we had come out as L1. We were obliged in the month of January by letters, by communication, we were obliged to put in some amount of money, security deposit, EMD, because of the impending holidays, because of Republic Day and everything, we had missed the bus by a day or two. On the 29th of January, by invoking a penal clause, which is appearing in the tender document, what they have sought to do is, apart from cancelling my bid and everything, they sought to invoke a penalty without hearing, without any notice. What they did is 3 years debarment from participating in any tender.
No circle. No circle.
I'm sorry.
No circles.
No, nothing.
Where is the department?
Please come to the writ petition once.
Where is the department order?
No, kindly see.
Page 55.
Yes.
P6.
The department order is 71.
71.
This is this Poschimbango Go Sampad Vikas Samstha, my learned friends, they have served notice even yesterday on them. Where is the notice?
Paschim Bengal Go Sampad Vikas Sanstha. Okay.
Some learned advocate did appear on the previous day. This is my last communication to them. May 7, 2026. With the Samstha.
Yes, Mr. Sonak Mukherjee.
Someone did appear. What I am on is, they have invoked in exercise of powers conferred by clause 55 of section D, terminated forthwith. 2. Your organization is hereby blacklisted for a period of 3 years with effect from 31/31/2026 from participating any tender, procurement, engagement process under Poschimbango Go Sampad Samstha and or other government institute as applicable. Pausing here for a moment, I have already missed the bus, insofar as 2 different tenders subsequent to this. What prompted me to mention the matter, I have filed I have taken your lordship's kind leave to file a supplementary affidavit. These are nothing to be concerned of. This is only the tender papers which have been appended, 2 which I miss, and the one that is forthcoming on the 15th, it is opening page 118. Right? Page date set page 103.
103 of this.
103, the date. I intend to participate in this tender because of this debarment order, which has been passed without natural justice. 103, right? This is a date. In this, I want to participate. I cannot participate because of this, impending
The last date is the 15/5. 15/5. So you want to participate?
This is by a different organization, but because of this debarment order, I can't participate.
Where is the tender document in this matter?
Yes, kindly comes.
What the work you have been given? Engagement of service provider.
Please
For
see.
daily operation
It is
of-
engagement. Please come to page 19.
Yes, I am there only.
Engagement of service provider for daily operation of farm, semen production units, IV5, IVF, lab, etc. in different places of West Bengal under Poschimbango Go Sampad Vikas Samstha, such and such. And the relevant clause number 55. Clause number 55 is a part of this document. Please come to this.
Where is the clause 55?
I'll just. Paragraph 31. That is at page 36 of the writ petition.
No,
Clause
what,
55.
what is the page 27?
I'm sorry.
Page 27?
I'll just.
That is a tender document. No?
Yes, a part of the tender document.
Tender document. Now come to the 27 last 3 lines.
Yes.
If anyone fails to submit the SD and APS prior to execution of the work for tender rules, penal measures including blacklisting of 3 years will be imposed against the L1 bidder. After receive the verification of the tender inviting. Yes.
This is one. Though they have referred to in the impugned order at page 71, but they have referred to this clause at page 36.
36.
Minor. It should be I'm sorry.
Yes.
It should be clearly understood that in the event of tenderer failing to accept
Where,
and
where,
execute,
where
this is
from
not
here?
the case.
Where
I'm
from?
paragraph 55, at the bottom of page 36,
55.
my lord.
It should be clearly understood.
Understood that
the
in the event of tenderer failing to accept and execute the agreement, work order, decision of Chief Executive Officer Paschim Bongo in this respect will be final and binding on the tenderer, including blacklisting for 3 years and forfeiture of EMD and security deposit. In case of any dispute, that is another aspect of the matter. I mean, what they have done is there is a tender summary.
Why another? The arbitration clause?
Arbitration clause is different.
Then
Arbitration is,
okay,
in case of any dispute.
okay.
Now,
So,
please see.
why the termination notice has been issued by including the blacklisting?
This is not a termination notice.
Why the blacklisting?
Because yes,
Non-corporation
kindly
of
come,
law.
kindly comes to certain communications,
So you have been awarded the work. This is a tender. Page 19 is the tender notice. 15th October. Correct.
Yes,
When the work order was issued to you.
The first thing is engagement of service provider. Please come to page 55.
Page 55.
This
Yes.
is dated, 13th of January 26.
Let LOA.
This is the letter of award.
Correct.
I was obliged to, you will have to initiate work by 1st February with Paschim Bongo such and such, and non-stamp, of rupees 100, etc.
So this is a letter of acceptance given to you.
Yes. Thereafter, this memorandum has been given.
So requested to you online transfer of 10 lakh.
Yes.
And along with the produce additional performance security within 2 months advance.
Now, what happened is at page 69, please turns to
69.
Yes.
Name this you have complied with this.
Yes.
Have deposited the amount.
I'm showing your lordship this. Please come to 2069 once.
Yes.
First communication through mail is 22nd January 26.
Correct.
Dear, I'm sorry.
Yes.
Dear sir, you are well known that we are planning to execute the same from February. Positively, you have received the LOA on 13th January. As per LOA, you have only made agreement with us. You are requested, due to short period of time, you have to submit the security deposit as well as performance bank guarantee by 27th January within 4 p.m. Otherwise, necessary action may be taken as per tender clause. This is the notice. Thereafter, on the 27th, the client, the petitioner writes to this organization, respected sir, in reference to your mail dated 22nd January 26 regarding submission of the security and performance bank guarantee be submitted owing to continuous intervening holidays comprising national holidays, festival holidays. Pausing here for a moment. 22nd, this letter is issued at 13:44 hours. 23rd is a holiday. Dates gulo dekho. 23rd was a Friday this year. 23rd of January was a Friday. 24th was a Saturday. Saraswati Puja was there on the 26th. And up to 26th were holidays. So we wrote to them on the 27th, owing to continuous intervening holidays comprising national holidays, festival holidays, and Sunday. The concerned bank remained closed for consecutive days. Further, even today, the bank is not operational, and as such, the required payment could not be effected. It is further submitted that prior to the whatever it is, the said it is further submitted prior to the commencement of the said. We made repeated attempts to contact your office telephonically. However, we were unable to establish communication. In view of the foregoing acts, we request the reasonable extension of time be granted. We undertake to submit the performance security within the earliest possible opportunity for your information and necessary action.
Yes.
And then 28th January, please submit the same by 4 p.m. That is what they wrote. And then they invoke this page 71.
29. So why you not submitted on 28?
My explanation is, we intended to, please come to the body of the petition once. Please come to, kindly come. Paragraph 11.
Yes.
Your petitioner, I'm sorry, page 6.
Yes, yes, yes.
Your petitioner states that petitioner, upon receipt of the letter of acceptance as well as draft formal agreement for the execution of the contract, had started taking steps by informing its banker HDFC to prepare a appropriate demand draft in favor of the respondent number 2 herein on 16/1 in terms of the BGRS system provided by the respondents herein. But unfortunately, due to certain unforeseen reasons on the part of the banker of the petitioner, the said draft or the bank guarantee as warranted in terms of the letter of acceptance dated 13 January 2026 could not be prepared within time. The respondent number 4 herein by a reminder email dated 22/1/2026 had informed the petitioner to take steps in the said matter by submitting the security deposit as well as such and such by 27 January 4 p.m. The petitioner upon receipt had tried its level best to transfer the said security deposit as well as furnish the bank guarantee within 27, but unfortunately due to continuous intervening holidays, etc., the petitioner, in spite of his best efforts, could not transfer and furnish the bank guarantee within 27. Accordingly, by email, the petitioner had sought for extension of time with an undertaking to submit the security deposit and performance guarantee at the earliest possible opportunity immediately upon resumption of bank operations. It is needless to mention that upon receipt of the email, the respondent number 4 by email dated had increased to grant a single day's time till 4 p.m. The petitioner must put in such and such. And then the petitioner states that that email was sent by the respondent number 4 at about 10:12 a.m. Paragraph 12 in the morning, and the same came to the knowledge of the petitioner through its authorized agent sometime around 11 in the morning. The petitioner, thereafter understanding the exigencies in the matter, went to its banker to take appropriate steps and remit a sum of rupees 10 lakhs by online transfer in favor of the respondent number 2, herein with a further instruction upon its banker to perform the to furnish the bank guarantee for a sum of rupees 50 lakhs within the same date. In favor of the respondent number 2. Your petitioner, in its greatest disbelief and utter dismay, the concerned official informed the petitioner that the said exercise could not be completed within a day's time and would require at least 48 hours time to transfer the sum as well as to furnish the bank guarantee in favor of the respondent number 2. However, the petitioner being in a helpless and
The in spite of service of notice, none appears on behalf.
I need to point out one thing to you. This tender, it was terminated on 29. I am informed that a fresh tender was issued and someone else has been selected. Today, my entire relief is restricted to this blacklisting part, because the tender, someone else has been appointed. What I wanted to also show your lordship, there is a tender, here. If your lordship kindly sees, at page 76. All the other bidders have been found to be debarred or have been found to be rejected. L2, L3, L5, everyone. Only I was blacklisted. Now, this tender has seen its day, it has been concluded in favor of someone else by issuing a fresh tender.
Fresh tender. So you
Fresh
have not
tender.
participated because of
Could
this.
not participate in
Correct.
Today, we are more aggrieved by the debarment order.
Correct.
That is the only.
That is department only, not tender, not the petition.
And it's my duty to point out.
Huh?
Be honest
None
and
appears on
candid.
behalf. None appears on behalf of the respondents. Full stop. The petitioner has filed the present writ application challenging the order dated 29th of January 2026, wherein the chief executive officer of the respondent number 2, respondent number 2 has terminated the tender issued in favor of the petitioner as well as blacklisted the petitioner firm for a period of 3 years with effect from 30th January 2026 from participating in any tender procurement engagement process under the Paschim Banga Go Sampad Vikas Sanstha and or any other institute of the government as applicable. At the time of argument, the petitioner submit that he is not pressing with regard to the termination, as after the termination, the authorities have processed the fresh tender and the work order has been issued to the third party. The petitioner is only agreed with the order of blacklisting. blacklist. Full stop. The respondent number 2 has issued the tender notice for engagement of service provider for daily operation of farm slash cement slash production unit slash IVF lab, etc. at different places of West Bengal under Paschim Banga Go Sampat Vikas Sanstha, LB-2 Sector 3 Salt Lake City, Kolkata. The petitioner has participated in the said tender and on 13th of January 2026, a letter of acceptance was issued in favor of the petitioner with regard to the said work. In the said letter, it is mentioned that it is directed the petitioner to execute an agreement to initiate the work from 1st of February 2026 with the respondent number 1, and also requested to submit security deposit in online transfer of rupees 10 lakhs along with produce additional performance security as 2 months advance amount, that is rupees 50 lakhs in the form of bank guarantee / online transfer / demand draft for a period of 24 months within 7 working days, though the bank guarantee repository system BGRS only as per the WBFIN rules for bank guarantee, which will be returned after satisfactory completion of the work. The petitioner submit that though the letter of acceptance was issued on 30th of January 2026, but the petitioner could not submit the security deposit and accordingly the same was informed to the respondent by a letter dated 22nd of January 2026 could not deposited the same. And on 22nd of January 2026, the respondents by an email requested the petitioner to submit the security deposit as well as the performance guarantee by 27th of January 2026 within 4 p.m. positivity. After receipt of the said email, on 27th of January 2026, the petitioner has sent a reply informing the respondents that owing to continuous intervening holidays comprising national holidays, festival holidays, and Sunday, and the concerned bank remained closed for consecutive days. Further, even on 27th, the bank is not operational, and as such, he required some time to make payment. In terms of the said notice, on 28th of January 2026 at 10:12 a.m., the respondent's authorities had directed the petitioner to pay the amount by deposit the security deposit by 4 p.m. on 28th of January 2026. Full stop. Counsel for the petitioner submit that on receipt of the email dated 28th of January 2026, the petitioner has contacted his bankers, but it was informed by the bankers that the 10 lakhs by way of online transfer in favor of the respondent number 2, along with the bank guarantee of rupees 50 lakhs within the same date is not possible. It will take further 48 hours to transfer the said amount, being the performance guarantee, being the security amount and the performance guarantee in favor of the respondent number. Full stop. Without giving any further opportunity, the respondent number 2 and respondents have issued the impugn notice by terminating the contact and blacklisting the petition. The main contention of the petitioner in the writ petition that the respondent authorities have blacklisted the petitioner for a period of 3 years by taking into consideration of clause 53.
My lord, yes. clause 55.
Clause 55,
Now that page, clause 55 is that page. I'll just show you a lot. Page 36.
clause 55. Clause 55 of the tender document, which provides that in the event of tenderer failing to accept and execute the agreement oblique work order, comma, decision of the chief executive officer, comma, executive officer in this respect will be final and binding on the tenderer, including blacklisting for 3 years and forfeited the EMT and security deposit if any. Learned counsel for the petitioner submitted, though there is a provision under clause 55 for blacklisting, but as per the settled law, the respondent ought to have given an opportunity of hearing to the petitioner before blacklisting the petitioner. But in the present case, the respondent authorities have not issued any opportunity to the petitioner, opportunity of hearing to the petitioner before issuance of the order for blacklisting of the petitioner for 3 years. Learned counsel for the petitioner has relied upon the judgment in the case of Blue Dreams Advertising Private Limited and another versus Kolkata Municipal Corporation and others, reported in 2024, volume 15, SCC 264.
Paragraph 21.
64, wherein the Honorable Supreme Court has categorically held that blacklisting always been viewed by this court as a drastic remedy, and the orders passed have been subjected to rigorous scrutiny. Full stop. Had the learned counsel for the petitioner produced the materials on record and the impugn order. The petitioner is only the petitioner at present only agreed with the order of the blacklisting. The blacklisting. In terms of the tender notice, comma, the petitioner has participated in such tender and the respondents authorities have issued the letters of acceptance on 30th of January 2026. As per the letters of acceptance, comma, the petitioner has to comply with certain provision, including the deposit of the submitting of the depositing the security deposit amount as well as the performance guarantee amount. Due to non-functional of the bank, as there was several holidays, and on 27th of January 27th of 28th of January 2026, it was not possible for the bank to immediately transfer the huge amount in the account of the respondent number 2, and it was categorically informed to the petitioner that it will take 48 hours. But without waiting further 24 hours, comma, the respondent authorities have passed the impugn order by blacklisting the petitioner. It is also admitted, it is also found from the record that the respondent authorities, before passing the order of blacklisting against the petitioner, have not issued any notice or no opportunity of hearing was given to the petitioner. Only on the basis of clause 55 of the tender document has passed the order of blacklisting against the petitioner. Considering the above, this court finds that the order of blacklisting issued by the respondent authorities against the petitioner is violation of the principle of natural justice, as the respondent authorities have neither issued any so-cause notice to the petitioner nor any opportunity of hearing was given to the petitioner. In view of the above, the operative portion of the impugn order dated 29th of January 2026, wherein the 29th of January, wherein the petitioner have been blacklisted for a period of 3 years with effect on 31st of January 2026 for participating in any tender of the procurement of the engagement process under the Paschim Banga Go Sampad Vikas Sanstha and or any other institute of the Bengal of the government as applicable is stayed for a period of till the disposal of the writ application. Full stop. The respondents are directed to file affidavit in opposition within 2 weeks. Reply, if any, that will filed within 2 weeks thereafter. List the matter on 25th of June 2026 under the heading adjourn motion.
I do not know whether I should pray for this. If one sentence can be added, in view of this order, there will be no embargo on the petitioner in participating in other tenders.
Already said,
Very-
what?
Just abundant precaution. Great,
Not so excited.
great.
Yes.
We have served by email, we have served by hand.
Nobody is there.
I do not know.
Where is the email?
No, are you appearing?
My lord, I am appealing on behalf of the respondent to bank.
Bank.
I undertake to file my Bhagavatam within the course of the day, my lord.
Okay. So what is your bank?
Well-
Which bank?
AU Small Finance Bank.
Why you're not appearing? Why your bank
My
is
lord, I
not
missed
appearing
the-
in spite of the service of notice?
I beg
Even the
pardon,
notice was served through the police also, your authority, your bank is not appearing.
I beg pardon, my lord. I
What
missed-
pardon? Give proper instruction to the bank.
I beg my.
Okay. Yes, what is your instruction?
My lord, my first instruction is that the requisition is not liable to be maintained in its present form because
Why?
the company has not been represented by any of its authorized representative. No board resolution authorization is there. And my lord, the petitioner number 2 is an employee of the company. The employee also has no board resolution or authorization.
Okay.
And the directors are present. So why the company is represented by an employee?
Okay.
And my lord, my second submission is the bank has received intimation notification from Ministry of Home Affairs that this company is involved in 28 numbers of fraudulent cases. We have received mail from the Ministry of Home Affairs. Now, on the basis of that intimation, we have fixed this amount. This is a current account.
What are the amount involved?
It is not clear, and we also don't have
Is
any
there,
instruction.
is there any lookout circular is issued?
My lord, Ministry of Home Affairs have mailed us to instructed us to freeze this account. Now, my lord, the amount involved in total fraudulent transaction has not been intimated to us.
So how soon you will file the report? You have
My
to
lord,
give out
kindly allow
report,
me
what notification you received?
My lord,
Then
kindly
they have
allow me to submit an
Then they have to
affidavit
make,
in
then
reply.
they have to make the ministry as a party,
Or
let
to
the
be
explain.
made a party of this
So you
in
have-
this case.
That's why you
First
give,
time information.
My lord, I would allow me to file it in affidavit in reply, my lord.
how?
I will file it through affidavit in reply, my lord.
You file the report. You file the report by
But I
of an
don't, I
affidavit.
don't have the report now.
File the report by of an affidavit
Yes.
within a week. Give the copy to them.
My,
Then you can take the or if but
and my lord, kindly.
if you today are not hearing any voice, otherwise I could have been directed to implement the ministry. You have any document you are having?
No, my lord.
That
Just,
what part
they have,
can be?
I just received the bill 2 days just before, my lord. I don't have that emails. The bank has sent some emails, my lord. I will ask the bank to file all the documents. My lord, kindly allow us some time.
I do not know the reason. I cannot meet anything.
Let they file the
They
report.
have to file a report, but
Then you have to
kindly
a
make
part-
it a short time
28
and then
numbers
we'll
of
have to respond. Because we have not been intimated in anything. There is
28
no
numbers of
communication. Your
cases, my
lordship will find there is no annexure in the.
So and so appearing for the respondent number 2. Police stop. He submits that the writ petition is not maintainable as the writ petition has been filed by the employee of the company without any resolution of the company and without any authorization of the company. They further submit that though the companies were having the directors, but the directors are not come forward to file the present date application. Number 2. Full list. Number 2. The counsel for the respondent number 2 bank further submit that the bank has freezed the account of the petitioner on receipt of the instruction of the notification you received.
Instruction.
The instructions from the Ministry of
Home Affairs.
Home Affairs. Ministry of Home Affairs or Corporate Affairs?
No, Ministry of
Home Affairs. Ministry of Home Affairs. Full stop. He pressed for time to file report by disclosing the same on affidavit. In view of the above, the respondent number 2 bank is directed to file the report by way of an affidavit disclosing all the documents within a period of 1 week from date after serving the copy to the learned counsel for the petitioner. The petitioner has liberty to take exception to the report if any
3 days.
within, but it will, okay, you mentioned the other quote.
I'll try. But I know this bench is not there, but the account being frozen.
Within 3 days thereafter, liberty to mention before the appropriate bench. Liberty to mention.
Grateful.
But would your lordship kindly pass an order that let the account not be declared NP?
There is a procedure. NP cannot be. How you are worrying of?
The effect is I am not serving interest.
Correct.
This is a loan overdraft account, FD overdraft account. So this overdraft account,
Let the report come.
let the status quo as regards the account be maintained.
Let the come. Don't worry. Don't worry. Yes, next.
Led by Mr. Bhattacharya, who's appearing online.
My lord, I am appearing, my lord, item 9 to 12. Kindly allow me to appear virtually today.
My lord, I am appearing for the respondent of bank, my lord, in these
My
matters.
lord, item 9, my lord, is, my lord, item 9 and 10 relates to declaration of fraud, whereas, my lord, 11 and 12 in respect of willful defaulters. Now, my lord, item 9, your lordship, we had moved the matter on the last occasion. There was, my lord, we were declared as a fraud. It was challenged on the ground that there was no forensic audit report which was served on us. While the challenge was pending, I have been declared as fraud again by a subsequent order, which is, my lord, at page 91. Now, the basis of that order is that another writ petition was filed by my husband, Harish Bagla. In that writ petition, my lord had passed an order which is at page 97, pursuant directing, my lord, the bank to give a copy of the forensic audit report to Mr. Harish Bagla. Now, admittedly, no copy of the forensic audit report has been given to the writ petitioner before your lordship. Now, since bank's contention is that since they have given a forensic audit report to Harish Bagla, on that basis that there was no sorry.
Last order है dictated ना. इसमें last में लिखो the mentality is point of mentality raised by the respondent bank is kept open. Point of mentality raised by the respondent bank is kept open. Huh? Yes, continue.
Yes. So, my lord, what happened was that in the second declaration, though I've already been declared as fraud, now the second declaration has come. The only difference is that it refers to my lord's order passed in another writ petition, and the fact that they have given a forensic audit report to Harish Bagla, that has been shown to be a ground for again declaring me as a fraud when no such forensic audit report has been given to me. So, my lord, despite of there being already a declaration of fraud, which was a subject matter of challenge, which is item number 10, during the pendency of that, I have been once again declared as a fraud without giving the forensic audit report to me.
Yes.
On the basis of another writ petition. That is, my lord, my short pointing item number 9 and 10. In fact, on the last occasion, Mr. Mahato was there. He said that he will take instructions. Possibly, if they want to give the forensic audit report, then this can be disposed of.
Yes.
My lord, as far as item number 9 and 10 are, my lord, taken up, my lord, these are filed by the petitioner, who is also a petitioner, item number 11 and 12, my lord. With regard to the, let me please complete, Mr. Bhattacharya, just 2 minutes. But since the bank was under the impression that no subsequent development of separation has happened between husband or wife, but we had served in terms of the earlier order passed in the earlier writ to the husband, yes. We were under the impression that it has been served and the wife has also taken the note, and there was no reply as such to that. That was the reason that we have asked my lord and we prayed before your lordship that all these matters should be listed together so that I can impress upon your lordship what is happening. That a company, Amrit Fields, has been declared fraud. Their directors, out of which these two are husband and wife, they are filing back-to-back writ petitions, my lord. They have already filed item number 10 against the fraudulent, against the order of declaring them as a fraud. Now, that writ petition separately was filed against the fraud, not together. And by the petitioner in this item number 9, my lord, separately. That order we, my lord, conceded. Yes, my lord was kind enough to allow us to, my lord, consider their subsequent reply, additional reply, and pass an order. So while passing an order, my lord, we were under the impression that Archana, if it, at any time, my lord, if my lord feels that, my lord, we have not acted in terms of the, my lord, natural justice is violated, my lord, then in that regard, with regard to the Archana Bagla, my lord, will kindly protect them in case if it is filled. But otherwise, my submissions are, my lord, we have deemed that they stay together and they have full notice of the, she has full notice of this order.
Whatever it may be, whatever it may be, you have to.
We will provide, my lord. But see,
The document to separate persons. It is not the husband and wife. Our husband has taken and wife is not required to.
no, apart from husband and wife, my lord, if yes, I have to cut short to my argument, my lord, item number 11 and 12 are filed together as a joint petitioners.
Okay.
Both petition, in both the petition, item number 11, both the Harish Bagla, Mr. Harish Bagla and Ms. Archana Bagla are petitioners. And in item number 12 also, they are joint petitioners.
So
that was the reason.
where
Whatever,
in
my lord, I leave it to your lordship, my lord. If my lord
Now-
wants, my lord, kindly do not set aside with regard to the entire order is concerned, my lord, declaring them as a fraud. Only with regard to Archana Bagla, my lord, kindly grant me leave to serve her. Let her file a subsequent reply, my lord, which shall be additional reply, and we will consider and will pass an order with regard to the petitioner herein.
With regard to my lord,
Only with regard to the petitioner herein, my lord.
my lord, may I just my lord, allow me? Item number 11 and 12 operate in different field. That is in respect of willful defaulter. That's a
But they're
different
acting
master
together.
circular.
They have knowledge
It
together.
really, Mr. Tiwari, we did not interrupt you, Mr. Tiwari. My lord, now item 11 and 12, last occasion an impression was given that these are connected matters. A declaration of fraud and a declaration of willful defaulters are not really connected matters because there I have a different point that the constitution is not legal.
But the
Now-
only reason why it was, my lord, brought before your lordship was to show that these two are, my lord, acting as a joint petitioners in both the matters, my lord. That was
No,
the
the
only
joint
intent.
petitioners in willful defaulters, and as my lord has written, husband and
Yes.
wife, separate directors, separate individuals.
But has been filed by both of them together.
My lord, if my lord takes my lord's order at page 97, if a similar order is passed in respect of Archana Bagla, my lord, we have no difficulty. My lord will see page 97 of item number 9, which was passed in case of Mr. Harish Bagla if a similar order is passed.
No, where is the order which impugned in item number 9?
Page 91 is the impugned order.
91.
Lordship kindly sees page 95.
Just a minute. 91 is the impugned order.
Impugned order.
Yes, ma'am.
4th of March. This is issued to whom?
This is issued to my lord, to including Archana Bagla, to Archana, Harish, and also the company. But here I'm only restricting myself to Archana Bagla.
That's why I am not allowing the persons to argue on online.
My lord, I'm sorry, ma'am.
Kindly takes to page 90.
90.
Is directed against both me and my husband, Harish Bagla and Archana Bagla.
Okay, this is to both.
Yes.
Okay. What is the penalty made paragraph?
Lordship kindly comes to page 95.
Yes.
Bottom.
Yes. In compliance of the Honorable Court's order dated 13 January, Harish Bagla, the forensic report along with the annexes were duly supplied to the
Petitioner, which is Harish Bagla.
Okay. That the writ petition was the Harish Bagla.
Yes, Lordship.
That is page
97, Lordship.
97.
Lordship's order. Operative portion at page 100. Yes.
Okay.
Para 12.
So after this order is passed, but this common order is passed. Petitioner and so and so. So this document was not served to the Archana.
Archana Bagla, that is me.
It has not been served to the
Not,
Archana. Bagla.
not sir.
Okay. So this writ petition is filed by whom? Archana.
Archana Bagla.
Archana Bagla. And another?
Another is
Both.
also Archana.
That,
Both the
no, that was the previous.
Yeah.
Item 10 is also Archana Bagla, ma'am. Item 10.
9.
Previous.
Item number 9 in only Archana Bagla has filed.
Archana
So her
Bagla.
contention is that in terms of the order passed by this court on the earlier occasion, in the application of the husband, document was given to the husband, but
He
not
declared
the
it as
Archana.
fraud, yes.
Okay,
That is pursuant to your lordship's order.
okay,
And item number 10 is the initial declaration of fraud.
okay. 10, 9, it's a 9. And 10 is?
10 is initial, challenging the initial declaration of fraud, which was pending. And while the writ petition was pending, a freshly the bank has
In that
declared.
what you have challenged?
Lordship,
In the first
Declaration of
petition,
fraud.
10, what you have challenged?
I have challenged the initial declaration of fraud, which is 19th August.
Because of non-supply of the document.
Yes, Lordship.
That was not disposed.
Not disposed of.
Only the husband application was
Yes.
disposed.
In fact, on the last occasion, Lordship had made this observation that how come they can do this without setting aside the previous order.
Okay. Yes, Mr. Tiwari. Now 9 and 10. 9 with regard to the disorder.
Yes, my lord.
Correct. So you have not served the copy of the documents to the Archana Bhatt.
We will supply, my lord, and with regard to this order, as far as this order impugned is concerned, my lord, let it be applicable to the Harish Bagla and the company. With regard to the, it should not be applicable to the petitioner herein. We will serve her again, not again. We will serve her and let her file an additional reply to the earlier show-cause notice. My lord.
Okay. So this is a WPA 9140.
This is 9140.
9140. What is the number?
Item number 9. 91.
Item number 10. Have a copy.
10, Lordship, is 1
You have an extra copy?
extra. With notings, Lordship, kindly.
Where is the so-cause notice? You are challenging the so-cause notice. Yes. Not
Item number 10.
item number 10. Where is the so-cause notice?
Lordship, kindly. Is that submitted? Page 51 is the communication. Show cause notice. Page 51. Lordship.
51. Archana Bagla.
The reply is at page 55.
Where in the reply where you mentioned that document is not supplied, which document you are relying upon?
Lordship. Lordship, kindly takes to page 56.
Yes.
At the very bottom, we have said this response is made under protest and without prejudice to my rights and contention.
Correct. No, where is the averment that what document is not supplied to you and you reserve the right to deal with the document? Where is that?
Lordship, we had replied it on merit, Lordship. We have not.
Then
But the order is at page 58, Lordship. 19th August.
page 58.
Yes. This order has also been impugned in item number 10. This is the initial declaration of fraud.
So, Mr. Tiwari, I have this setting aside both the order with regard to the document, then you take appropriate. The item number 9.
My lord is not audible, my lord. I'm sorry.
The item number 10.
Yes, my lord.
What is your item number 10?
My lord, item number 10, my lord, they had replied initially. Let me my lord, provide them as FAR, my lord, and let them find an additional reply. We'll consider and we'll pass an order.
Okay.
I will stick to that. My lord will pass an order without recording my submissions, my lord. Like this order, my lord, both the petitions can be disposed of, my lord, 9 and 10.
That's what I'm telling.
Yes, my lord.
So why this is started? So I am disposing of this. Yes, Mr. Bhattacharya, 9 and 10 I am
Yes, my
disposing.
lord, kindly dispose of, yes, my
the petitioner has filed,
Address, my lord, physically on Monday on.
Archana Bagla has filed the present writ application being WPA number 1633 of 2026. 2026.
Lordship, this is item number 10.
Ah,
One
Item number. That's why I'm giving the writ petition. Otherwise, it would be difficult.
Right.
Challenging the so-called notice dated 28th of April 20. Where is the prayer?
Where is that? Lordship,
Challenging the so-called notice dated
Page 20, my lord. 20 of item 10.
28th April 2025. And where is the order?
order to the
And the order dated
19th August
and
2025.
the order dated
19th August 2025, communicated to me on 10th of September
and the
2025.
order dated 19th August 2025.
Page
served
57.
to the communicated to the petitioner
On 10th
by a
September.
communication dated 10th of September 2025. 2025. Counsel for the petitioner submit that after receipt of the notice, so-called notice, petitioner has submitted the reply. But the authorities have relied upon certain documents in the so-called notice. It is not the case, the forensic report is not served to you.
No.
That's a case in a writ petition.
It is क्या No, it's submitted the reply. Full stop. The allegation, the contention of the petition in the present writ application that
Lordship, we have given it in our grounds, page 15, ground 7.
the contention of the petitioner in the present writ application that
To disclose the show cause.
that the respondent authorities have not provided the forensic audit report and the other documents on the basis of which the so-called notice was issued. See, further submit that on the similar ground, the petitioner and the husband of the petitioner, namely
Harish Bagla,
had filed a writ application being where is that order?
page 97, Lordship.
WPA number
9140.
28686 of 2025 within bracket Harish Bagla versus Punjab National Bank and others. And this court, by an order dated 30th of January 2026, disposed of the said writ application.
Lordship, 13 January read with 22nd January as corrected.
Read with the corrected order dated 22nd of January 2026, wherein this court directed the respondent bank to supply the forensic audit report to the petitioner through pen drive or through email to the petitioner within a period of 4 weeks from the date of receipt of this order. And on receipt of the forensic report, the petitioner is liberty to file the supplementary reply to the so-called notice within a period of 4 weeks. Full stop. This court has also given liberty to the petitioner to the bank on receipt of the supplementary reply from the petitioner, if any, against the forensic report. The bank shall pass a reason and speaking order within a period of 4 weeks thereafter. Full stop. In the present case, also the main grievance of the petitioner that the so-called notice has been issued without serving the copy of the forensic report and the document relied by the bank. Accordingly, the writ petition is disposed of by directing the bank to supply the forensic audit report and the documents which the petitioner, which the bank has relied upon while issuing the so-called notice through pen drive or through email to the petitioner within a period of 4 weeks. Within a period of 4 weeks, Mr. Within a period of 4 weeks from the date of receipt of this order. On receipt of the said documents, if any supplied by the bank, the petitioner is given liberty to file supplementary reply to the so-called notice within a period of 4 weeks thereafter. On receipt of the reply, if any, in receipt of the supplementary reply, if any, filed by the petitioner, again the forensic report or any of the documents supplied by the bank to the petitioner, the bank shall pass a reason and a speaking order within a period of 4 weeks thereafter. In by the above direction, the WPA number 1633 of 2026 is disposed of. Now,
My lord, one indulgence. My lord, the order of declaring them as a fraud is dated 24th of March. If my lord can kindly indicate that this is set aside only with regard to the petitioner here in my lord, not in toto.
The petition, as the petition is given liberty to file supplementary reply if any further document supplementary reply after the receipt of the forensic report and a copy of the forensic report and any of the document which the bank has relied upon. Accordingly, the where is the order? Default order in the first rate petition. Acha, the order dated 19th August 2025. 19th August 2025.
58, Lordship.
My lord, it is a fresh order that is passed on 24th of March 2026, my lord, in 9140.
That I will come to that. Now I am first.
My lord.
Is set aside and quashed only with regard to this petitioner. Only with regard to this petitioner.
My lord, also order dated 24th of March. Because in this
that I am coming.
My lord.
I'm passing the common order. Otherwise, it will be confusion.
I bow down to it.
The petitioner has filed the present writ application being WPA number 9140 of 2026. Oh, to wapas karo. 2026. और आपको चाहिए होगा ना वाला writ petition 2026 challenging the impugn order dated 24th of March 2026 wherein the bank has declared the company as well as the petitioner as fraud. The contention of the petitioner in the present writ application that the bank has not served the forensic audit report and the documents relied by the bank while issuance of the forensic issuance of the order issuance of the so-called notice and the willful defaulter order. According, the petitioner has filed a writ application being WPA number 1366 है ना ऊपर वाला first 1633 of 2020 जो भी है देख लेना 2026. During pendency of the writ petition, the bank has passed the impugn order declaring the petitioner has fraud. Learned counsel for the respondent bank submits that in terms of the order passed by this court on 30th January 2026, read with the corrected order dated 21st of January 22nd of January 2026 in WPA 28686 of 2025 within bracket Haris Bagla versus Punjab National Bank and others. The bank was of the view that the Haris Bagla is the husband of the petitioner herein, and as such there is no necessity to serve again the document to the petitioner herein. Thus, the bank has passed the impugn order by declaring the petitioner as fraud. Declaring the account of the petitioner as fraud. Full stop. Considering the full stop, the the writ petition filed by the petitioner being WPA number 1666 जो भी है 2026 was disposed of by this court by an order today by directing the bank to serve the forensic audit report along with any of the document which the bank has relied upon at the time of issuance of SOCAS notice, and the willful default order has also is set aside. Accordingly, the interim order dated 24th of March 2026 is set aside only with respect of the present petitioner, namely Archana Bagla. Archana Bagla. Full stop. This order will not prevent the bank to pass appropriate order against the petitioner after receipt of the supplementary reply, if any, filed by the petitioner in terms of the order passed by this court in WPA number 1366. ठीक है? WPA 1940/2026 this court. That's all.
Yes.
Obliged, Lord. Lord, as far as item number 11 and 12 is concerned, Lord.
What are the other two?
To willful defaulter, it operates under a separate master circular.
Only thing, my lord, may I just say this? There are other points also. I'd like to argue this matter physically. If you, my lord, may keep 11 and 12. Yes, my lord, very well. Keeps it after vacation.
After vacation, my lord, on 10th of June, my lord, it's permissible.
10th of June now, then I'll come the second week. And,
yes, my lord, I shall come.
1920.
Yes, my lord, any day convenient.
Yes, any day convenient to my lord.
Let the matter appear on 17th.
Grateful, my lord, deeply obliged.
Deeply
and
obliged,
my apologies, my lord. My apologies.
Obliged.
Grateful, my
Well, I'm for the RDSO, but
Yes.
my inspection has been done, my lord. And my lord, it has been placed before the authority. Well, at the gradually one, with very beginning, well, I have submitted before lordship, well, because Pan India procedure, my lord, on staff is very short, my lord. They are taking chronologically,
Okay,
they are taking steps. Yes, my lord. They are taking the decision, relisting process, my lord, is going on. Those who are already been done, that decision is taking categorically, sequentially, it is taken, my lord. So I am taking 1 week time or 2 weeks time, my lord. In the meantime, they will be relisted after considering the
I
status.
don't stand in the way, but my only apprehension is not the uncanny promptitude with which the delisting is done should also be commensurate with the position of restoration. Otherwise we seek to lose out on tenders. We have to maintain a staff of 200 employees at the factory. We have to pay our wages.
But my learned friend is submitting one of the inspection is done by the on behalf of the RDSO.
Right.
And they have placed it before the authority. And they will recheck and then they take the decision.
The revocation of delisting order.
Entire problem is come because of our second item, my lord. The entire all the 5 items they have not purchased, my lord. They have only self-manufactured.
They are not going back. It has been now done.
So yes, well,
please expedite the process so that I can survive.
Exactly. But
I am disposing of this.
Lordship.
So
In accordance with law, shall take decision.
In terms of the joint note, the inspection has already been completed. The authority director to take appropriate decision within a period of 1 week.
But some more time because chronologically we are taking steps. Because those who have already been inspected, their decision is taken.
Make it clear. But the delisting was done because I have not upgraded my machinery within a particular time.
Correct.
Now they have inspected and found this to have been complied with. So it requires a formal order of revocation of the delisting order. That's probably a ministerial job left.
They have to pass
It
an
will be
order.
done
They have to pass an order for delisting.
Yes,
but kindly direct me a time frame.
That's how much
For
time?
the decision is
2 weeks. I am seeking fortnight, 2 weeks. I am not seeking more time. Because on 2nd May, I have already inspected.
Okay.
Today is 8th May.
Learned Council for the respective parties submits that the materials supplied by the petitioner have already been inspected by the authorities through third party.
No, we had
has been inspected
through the railway inspector. And RDSO later on.
Has been
It
inspected.
is machineries, not materials.
Machineries. क्या बोला? petitioner-
machinery, they have
both the-
self-manufactured.
both the parties, the machinery supplied by the petitioner has inspected by the concerned authorities. Not the counsel for the petitioner submit that if the report is submitted, the name of the petitioner is to be delisted from the, what is the prayer?
Delisted, I was delisted at page 150.
150.
On first,
Delisted from the approved list of vendors.
on 1st March possibly.
1st March 2026.
1st March 2026, my lord. That is, my lord, page, my lord, 151.
But paragraph 2,
Of the
temporarily
sub-
delist your firm from the list of vendors for manufacture and supply of rail pads.
150, my lord, on 1st March 2026.
No, full list of, inspected, full list of, full list of. The, by an order dated, what is the date?
But the date is not,
The date is, my lord, 1st March.
date is as
2026.
signed, not that as signed date is at the bottom left.
Yes.
Digitally signed by Pushpendra Kumar, date
7 January 2026.
1st March 2026, left hand bottom.
By an order dated 1st March 2026, the railway authorities have delisted the name of the petitioner from the approved contractor.
Approved vendor.
Is approved vendor, my lord, by the
Approved vendor.
RTSO.
Approved
Vendor for manufacture and supply of rail pads.
approved vendor for supply and manufacture of railway
Rail pads.
pad.
rail pads. This one, huh? Supply of rail. Manufacture and supply of rail pads. Full stop. Now the authorities have already conducted the inspection, and the concerned authority has to take decision for recalling of the order, impugn order dated 1st of March 2026, and to list the name of the petitioner as a improved, as an approved vendor for manufacture and supply of rail pads. In view of the above, the writ petition is disposed of by directing who is the authority to
But
take
should be,
decision.
My lord, RDSO, my lord, that is, my lord, respondent number, my lord.
should be respondent number 6.
Respondent number 6, my lord, direct,
5 or 6.
Number 6.
my lord, 5 and 6, my lord.
না যেকোনো একজনকে বলো
The respondent number 6 or the competent authority are directed
Everything
to
covered.
consider the report, the inspection report, and to pass appropriate order within a period of 2 weeks from the date of receipt of this order for approval of the name of the petitioner as a approved क्या था? ठीक है? For supply of so and so. In police stop, WPA number so and so is disposed of.
But only one, not I am at your lordship's mercy, not a very hard fought and not an interim order has been vacated, item number 3, same party.
Why your juniors are doing like this?
Not tension for a matter sometimes not causes not this. Not I can
So not tension, because this court is also having tension.
Yes, not I understand.
At 10:30 a.m.
And not they thought that since your lordship will not be adorning the bench since Monday, so we have to get it extended till by this
Because
day.
it is already specific, and if it is not extended, I am giving
Yes, yes, but
opportunity.
your lordship
Fourth of
gives us quite indulgence. We could have mentioned it at 3 o'clock even.
correct.
Yes, but
Even you, I am taking a 4:30 also
My
at
lord,
the time of raising of the court. Why you are mentioning all these things?
if your lordship will kindly not pardon me, note that.
Okay, we'll see to that.
But we are also
Grateful to you,
grateful,
extremely grateful to you.
we are also grateful that you are also always taking out
The court is here to hear the advocates.
a generous approach.
Yes.
I am opposing these applications.
Similar tea time matter.
What matter?
Tea time matter.
Tea time.
Tea time. So
The issue is with respect to Lord.
mere hearing the matter would not suffice the purpose unless we get the taste of tea.
That's upon them.
Right.
If they give subsidy, we will be in a position to.
Yes.
Lord, the issue is with
Mr.
respect
Karmakar will not supply the tea so that you can take the taste of the tea.
Right. But at the best, we can make request to an ardent friend
If you not supply,
doing-
he can offer one cup of that tea.
cup of tea. Yes. Right.
Yes.
Lord, this issue is with respect to Lord subsidy of Lord tea subsidy on 2 grounds. One, Lord, under the orthodox.
It will take time.
Lord,
But-
not much time.
Not
Not
much
much
time
time,
because
But it will take.
I'll only,
before proceeding,
I'll
before
conclude
proceeding,
in
my
15
lord,
minutes.
if my lord, if I get this opportunity to just to bring it to your lordship's kind notice, that the subject matter of the writ petition is whether, my lord, since the T-board authority had refused to grant any sanction and subsidies subsequently. The point is, according to the scheme, at first sanction or subsidy subject to sanction of the, according to the scheme, yes. Now, my lord, this point has already been decided by our High Court, by a coordinate bench, by Justice Sinha's order, and subsequently the division bench upheld the order of the London single judge. Now, the entire matter, the same issues are now before the Supreme Court. Supreme Court, my lord, I have come with all orders. Now, if your lordship decide this matter afresh, despite the fact the point of law has been settled down.
It is Lord,
So,
one issue.
one
has
thing I
been
can do, I
decided
can
by-
share the judgments, unreported judgments.
Go through it.
Very well.
Very well.
Go through
One
it. It is
issue has already been decided in this chapter based on which my lord subsidy was rejected. That's Justice Gangopadhyay's order.
No, that
I have
is
annexed that. Lord, if some other judgment is
other
sought
judgments.
to be
You
relied
what are
on,
the
Lord,
judgment? You give it.
I'm sharing these judgments in London friend and also let it place.
If it is in the Supreme Court, then
Yes, it is before Supreme Court.
Lord, it's related, Lord.
Absolutely related.
Because my specific case is, Lord, sanction was granted, we were within time, and Lord, Justice
One copy,
Gangopadhyay's
Lord, I'm-
ratio does not apply to us at all.
And this is well, division bench judgments, upholding the London single judges judgments and order, and this is Honorable Supreme Court. So, get out to the other. At first minute, may I draw your kindly attentions at page minute 30 at page no 30, issues. Page 15 of the London single judges order. The issue which had been framed for adjudications.
Yes.
Page 15 at the bottom, issues to be decided.
Whether the writ of mandamus.
Whether the writ of mandamus can be issued commending the authority to release subsidy in favor of the petitioner on obtaining NOC, and second come final inspection reports. Next issue, whether a declaratory order can be passed declaring that the restriction of payment of subsidy in accordance with the earlier schemes cannot be made applicable in case of petitioner. So far, issue number 1 is concerned, that is the grievance of the petitioner. Now they are claiming before your lordship through these writ petitions.
Yes, Mr. Karmaka, consider this.
I'll definitely will not consider a comeback.
Learned Counsel appearing for the for the respondents.
I'm for the response.
Counsel for the respondents submit that this in the similar issue, this court by an order dated 2nd May 2025 has passed an order in WPA number 3152 of 2022. And the said order was carried to an appeal being MAT 46 of 2025. And the appellate court has upheld the order passed by the coordinator of this court. Now the matter is pending before the Honorable Supreme Court. Copy of the order passed by the Honorable Single Judge, passed by the coordinate bench, Honorable Division Bench, and the Honorable Supreme Court has been handed over to Land Counsel for the petition. Land Counsel for the petition prays for time to go through the orders and make appropriate submission on the next date fix. In view of the above, the case is adjourned. Let the matter appear on 23rd June.
Lord, fixes a
Yes.
time, Lord. Fixes
Then
a
June, July. To go July.
If not in the first 10 matters, not within first.
जुलाई में देखो क्या कब पड़ेगा 2 बजे
Just have a time.
by that time you see the Supreme Court what the
Yes,
Supreme
what
Court
order comes subsequently.
16 July 2 p.m. come on that. 16 July 2
Grateful.
And Lord, this Lord judgment, Lord, perhaps is not applicable
okay
to us.
come to that
We
right go
factually-
through you go through next
Grateful.
Lord, I beg to appear for the petitioner. Lord, this is a peculiar case, Lord, of the railways, Lord, high-handedness. When, Lord, I was directed, Lord, to
who is appearing for the railway
I am appearing on behalf of the Union of India, led by Mr. Ravi Prasad Mukherjee.
huh
Led by Mr. Ravi
you are
Prasad
appearing
Mukherjee. Yes.
yes
But the issue here is not, I was not granted a tender not for construction of deluxe toilet, not pay and use toilet in the station. Not the system was 15 years license I have to pay each year. After construction, I will continue to carry on with that business. Now, Lord, I constructed in 2022, the tender was floated. I became successful. I constructed the toilet. Within 1.5 years, Lord, suddenly I found Lord, debris and Lord, all other construction materials are being Lord, gathered in front of the toilet to render it unusable. So, Lord, I indicate that before the railway authorities that my toilet is unusable, and that's the reason why, Lord, I cannot earn any revenue from them. So, Lord, they started demanding, even if it is unusable, you start paying us the license fee. That was their claim, completely ignoring my complaints with respect to. Finally, they came up with a clause that few people can access to your toilet. That's why you need to pay the license. So, I indicated that you please give me a separate plot so that I can construct a new toilet and I can resume my business and I'll pay whatever. Whenever I am in a position to use the toilet, I'll pay whatever is required, the license fee. One fine morning, without giving any hearing, anything, my contract is terminated. Kindly, straight away, comes to page 74.
There is no arbitration.
Lord,
There is no arbitration.
there is a clause, but Lord, I would make this submission, Lord, that arbitration clause is ambiguous.
51. 51, page 51.
My Lord, page clause
A dispute between the license and licensee in connection with the purpose shall be governed by the provision of arbitration.
2015 ordinance.
Condition pertaining to arbitration and yes.
So my submission before your lordship is this. This is a completely ambiguous.
Where is the termination?
Termination letter, my lord, kindly comes to page 74.
Despite issuance 7 days and 48 of same.
No hearing given, nothing.
Yes, well, how you have dumped the construction material in front of this the Sulabh Sajal, whatever it is, and you are telling that you have to pay. How?
Kindly not see 60, page 60.
How? Which area? Which area?
No, Devghar station. Asansol division, Devghar station.
How it can be? You are restraining for using of the toilet and you are asking the fee from the contractor. What is your defense?
Actually, I have to take instruction.
So, not to give her effect. In the meantime, you will, what will happen to this? Where is the 47 days and 48 hours notice?
Yes, Lord, that they have given. Lord, kindly comes to Lord,
72
page
is the
73.
72 is the 48.
Yes.
License fee, as per the agreement.
The same, Lord, old story. Give us money.
When you made the report that they have dumped the construction material, where you have made
Yes,
a
the
complaint?
first tally, my first representation was, Lord, page 54. October 12, 2023. That's my first representation. That I asked, return my investment because I have come to learn that you are going to demolish my toilet and you are going to relocate it.
And where is the tender?
Lord,
Where
my
is the
tender,
work
the
order?
agreement.
Yes, agreement.
Agreement, my lord, is at page 39. And your lordship would find, my lord, in all pages, my lord, the signatures are
For
there.
a period of 15 years.
15 years.
That is the
But
date.
I'm not for a second saying that I'll not pay the license fee. If I'm using it, I'll definitely pay.
No, when it was terminated, it was 15 years, 2010.
Yes, 2022. This
22.
commences on February, my lord,
What
2020.
is the what is the date of the agreement?
The date of the agreement is 28th of February 2022. And my lord, the commencing date was November 2021 till November 2036. My lord, that your lordship would find. Kindly, my lordship takes up page 39 once. Not 39, I'm sorry, my lord. Kindly comes to page 40. Kindly comes to page 40, my lord. Clause 2.
21 to 36.
My lord. I have invested the money, I have paid, and I will definitely pay as and when I am able to use.
Yes.
For a commercial purpose.
36, you have given the 48 hours notice on 2026 and 7 days notice, then you are terminated, but you have not given any reply to the construction material which you have put in dumped in front of the toilet, which cannot be used.
One thing I must also show to your lordship, lord, kindly comes to page 67. This is a complete cryptic version of, lord, my all complaints of, lord, 3 years. And I have also written to them in reply of how I have dealt with in page 68. A very spacious reply. And Lord, page 68, I have dealt with each and every, Lord, the clause that they have indicated with, Lord, WhatsApp chat.
Yes, what can be done?
Lord, may I suggest only one thing, Lord? Kindly, Lord, subject to what falls from Lordship, Lord, kindly stays the termination, Lord, directs them to consider my representation and let them come up with a reasoned order. That's exactly what I'm wanting, nothing more than that. Because I have a right under contractual right. They are asking for money for a time period when I am unable to use the toilet. And this is their reply. And I have specifically indicated, not with dates at page 68, your lordship would find the manner in which entire thing has been proceeded with.
What is the present situation?
The present situation I have annexed, not page
Still.
60. Page 60.
Still there.
Yes. Present. 60, 61. Oh, the present is sealed. No, this is of 2024. The present is sealed. It has been sealed. Terminated and sealed. But I have constructed the toilet not for not staying there. But I wanted to do some commerce.
Let you file the report. How soon you will file the report?
4 weeks.
It is a soon. The problem is that this code will
Actually,
not
they
be
are not
there.
communicated with us.
You file the report within 2 weeks, serve the copy, and you take the exception. Then I am fixing the reopening day. What can be done?
Thereafter,
better.
not some Lord
What termination final order? What is the stay? What interim order can be passed? There's a termination. It cannot be revoked unless and until something.
I understand, Lord, but the difficulty here.
Cannot. The petitioner has filed the present writ application challenging the termination of the contract dated 9th April 2026. Full stop. This could find that a report is required to be filed by the railway authorities. Accordingly, the railway authorities are directed to file report within a period of 2 weeks after serving the copy to the learned counsel for the petitioner. Full stop. The petitioner's liberty to take exception to the report, if any, within 2 weeks thereafter, leaves the matter on 9th of June within 10 matters.
Lord, let this direction be peremptory, else, Lord, I am a victim.
Let them come. Let they come.
Great.
Next.
Obliged.
But I am appearing for the petitioner.
17.
16, my lord, also.
16, file is not here.
17, my lord, same matter, 16, 17 and 18. Analogous matter. My lord, 17.
What is the matter?
There is a scheme, my lord, by the central government to provide loan to the unemployed, educational loan.
Who is appearing for the respondent?
Bank authority, madam. Here, Punjab Nationalized Bank. My lord, I have served the copy. The affidavit of service, my lord. Only prayer of before lost is directing the respondent concerned in terms of the scheme, they have to consider the loan application. That is, my lord, page 27.
What is your case? Who are you?
My lord, I am applied for loan and the educational loan.
What education?
That
What?
is the nursing.
Huh?
Nursing training.
You want to go to the, your
3 years nursing training. ANM.
so you are admitted for the set course, or you want to go
Yes,
for the
yes,
set course? You are admitted?
Yes.
When you are admitted?
So if the bank authority is not granting the
No,
loan
no. When you got the admission in the set course?
in the year 2024,
24.
running, prosecuting this
Where is your admission? Where is your admission?
application.
Where is your admission in the college for the
But your lordship will get it from page 28
page 28?
in the loan application. Duration of course 3 years. I got it.
28.
Page 28, loan application. Name of the course, GNM. Nursing.
Name of the course, where it is? Duration of the
second.
course, name of the course, JNM. General Nursing?
Name of the institution.
General Nursing Midwifery? What?
Yes.
Yes. Commencement 2024.
Name of the
Completed
then duration of the
27.
course, then date of the commencement. Date of completion, my lord, got it?
Yes.
27.
27 page date of
31st October 27.
and date of
The grievance of the petitioner
Date
in
of
the present
application 7th
the
November
grievance of the
24.
petitioner in the present application that the petitioner has got admission in the course of general nursing midwifery, midwifery in the Cosmos Institute of Nursing on 1st of November 2024. The duration of the course is of 3 years. 3 years. Full stop. The petitioner has applied for education loan before the which bank?
Punjab National Bank,
Before the
respondent number 7.
Before the respondent number 7. Before the respondent number 7. In terms of the scheme. In terms of the scheme.
In terms of scheme, page 14.
In terms of the
Model
scheme,
educational loan scheme.
which is annexed in terms of the scheme, but in spite of the receipt of the request of the petitioner, the bank has not considered the application of the petitioner for grant of education loan to the petitioner for continuing her study or as general nursing midwifery. This court find that the application filed by the petitioner is still pending before the respondent number 7.
7.
And the same has not been considered. In view of the above, the writ petition is disposed of by directing the respondent number 7 to consider the application filed by the petitioner for grant of education loan by giving an opportunity of hearing to the petitioner within a period of 3 weeks from the date of receipt of this.
In the scheme, it is 15 days.
Huh?
It is in the scheme.
within 2 weeks kar देना. Within 2 weeks from the date of receipt of this order, or क्या बोला? To dispose of the application filed by the petitioner for grant of education loan within a period of 2 weeks from the date of receipt of this order, and to communicate this order to the respondent, to the petitioner within a week thereafter. ठीक है? WPA number ऊपर लिख लेना. Despite service of notice and affidavit of service filed by the petitioner kept in the record, despite service of notice, none appears on behalf of the respondent. Next.
Not grateful, my lord, after long days, my lord, I am appearing.
Yes.
18, my lord, loan has been sanctioned.
18.
File is not.
This was 17.
File is not here, my lord, loan has been sanctioned.
Then what has happened?
Then, my lord,
Nothing.
nothing is
Disposed of.
there. Maybe
Yeah.
disposed of. To the,
Which matter you called? 18 you got the order.
yes,
Loan is sanctioned.
loan is sanctioned.
You have a copy of the writ petition.
The petition, yes, 18 আছে.
Yeah,
No, no, my
record an order 18. 18, na?
18.
18. Learned counsel for the petitioner submit that though the petitioner has filed the present application that the bank has not sanctioned the education loan amount, but during the pendency of the present application, the bank has already sanctioned the loan amount. And as such, under such no order is required to pass in the present application. In view of the above, WPA number 16419 of 2025 is dismissed as infractious.
One thing, my lord, may I say? My lord, with 16, my lord, that matter may be a similar matter.
16 already there.
Along with 16.
Along with 16, my lord,
Are also mentioned. Also mentioned.
same matter, I have.
Then next.
My lord,
My lord, I beg to appear on behalf of the second respondent.
Yes.
Your Lordship, I am appearing on behalf of the writ petitioner. Your Lordship, I am led by my senior Mr. Choyan Gupta, who is on legs before the division bench. Kindly passes it over to the second half. Your Lordship, wait for me.
Second half other matters are there.
Lord, then maybe may it be taken up on Monday, because I also need some time to lordship prepare.
My lord, it's a little urgent matter, my lord.
What is the urgency?
Your Lordship, this is a tender matter. My tender was issued. Letter of intent was given to me. Work started. After that, by an illegal and arbitrary termination notice, my tender was revoked. So I was terminated. Lordship, the letter of termination states that there has been
So your prayer is only for the refund of the security deposit?
No, Your Lordship. There has also been a 60 months ban on me and my joint venture partner against any tender.
If lordship kindly takes up my lord's last order, there was a direction upon the petitioner to serve upon the third respondent.
We have, sir. Yes,
because lordship was of the opinion that since disputes had cropped up between the petitioner and the third respondent, because they were joint venture partners. So lordship, it was necessary to hear out the third respondent also to.
Your Lordship, I can show from the records that at the time that they have claimed that there were disputes, there were no existing disputes between the parties. Even the third respondent has issued letters to them and stated that there has been no disputes. And the letter by which that they are claiming that there were disputes was never issued by the third respondent, who was also my joint venture partner.
So what can be done? The senior is not here. What can be done?
Your Lordship, if Your Lordship keeps at 2 p.m., otherwise I can start. Your Lordship.
Yes, you start, no problem.
Very well.
But you start.
Your Lordship, since they said that there was a direction, we have served all the respondents again, and an affidavit of service has been filed today.
May I just say, I mentioned the matter day before yesterday before Your Lordship, and I had when Your Lordship directed the matter to appear today, I had also intimated by email as also hand service and courier to all the respondents, including the third respondent, my JV partner.
You are appearing for whom?
For the second respondent, Braithwaite and Company.
Braithwaite. What about the ministry? It is
My
the
lord
you
had heard
only.
this matter at length, and then only my lord on the last occasion
Okay,
directed.
yes, what is the matter?
on-
I'll state the fact in before. Your Lordship, Maharashtra State Road Development Corporation had issued a request for proposal and implemented the respondent number 2 as implementing agency for certain tenders, for removal and disposal of soil and scrap materials from the Samruddhi highway that is being made. So after that, the respondent number 2 had issued letter of intent upon the respondent number upon us. We, in consortium with the respondent number 3, we make a joint venture. We apply, we get the letter of intent, and we start the work. Power of attorney was given to me.
Who?
To my director
Hmm.
by the joint venture.
Hmm.
Lordship, the power of attorney is at page 44.
Hmm.
Issued by the third respondent upon us. Main party completed.
Yeah, then
We start the work. Then on 16th August 2025, we suddenly receive a notice that they have received that there are some antitrust between the joint venture partners. So they are terminating the tender.
My lord, may I interject for one moment? Because lordship, my learned friend is saying that tender he had started the work, his client. Lordship, that is not the case. Letter of intent was issued. Later on, lordship, when my learned friend will place the cancellation, lordship, there my lord will find that the letter of intent was terminated. So what?
where is that termination?
Termination is at page
termination is
176, your lord.
এইটা কবে আমাদের ওরা যে নিজেদের মধ্যে যে আরবিট্রেশনটা ইনভোক করতে চেয়েছিল না সেই সেকশন 21টা তো আমার এতে না আমার নোটিং এ দেখতো আরবিট্রেশন নোটিশটা দিয়ে দেওয়া আছে কিনা
Yes, it is between you and your partner. So how the respondent how the respondent number 2 will.
May I just address your lordship? My lord, what happened after letter of intent was issued to me, without giving me any notice or without giving any prior opportunity of being heard. My lord, suddenly the tender was I had paid my performance the tender earnest money deposit of 5 lakhs. Then I had paid performance guarantee of 25 lakhs, and thereafter also I paid around another 50 lakhs or so, aggregating to 65 lakhs and odd, my lord. My lord, without giving me assigning any reason, and during the subsistence of my tender and the LOI given to me, the work was allotted to somebody, the third respondent.
No, that's why you entered into along with the JV.
Yes, ma'am.
So JV is not performing. That's why there is a description.
Yes, ma'am.
Perhaps that is not the case.
Yes, that is the case. 170.
My lord, may I also indicate, if my lord will kindly take up page 189 of my lord's brief, that is annexure P24. Lordship, this is a notice under section 21 of the Arbitration and Conciliation Act sent by the petitioner to the private respondent number 3.
Yes.
My lord, here if my lord sees that they kindly takes up the third paragraph.
Yes.
However, it is a matter of record that due to your unilateral action, breaches and communications addressed to BCL, the said LOIs were illegally and prematurely cancelled by Braithwaite and Company. That is the second respondent through its letter dated such and such. in the said letter, BCL has explicitly recorded the cancellation of LOIs, forfeiture of deposits, and blacklisting of JV for a period of 60 months arose directly on account of breach of JV conditions, failure of compliance, breakdown of interparty trust. So, Lordship, thereafter they go on to invoke the arbitration clause, call upon the other respondent to nominate an arbitrator. So, Lordship, it is very clear. Also, Lordship, if my Lord takes up my report, Lordship, there I have brought on record the two letters that the second respondent has received from the third respondent, who was the JV partner of the petitioner. Lordship, if my Lord kindly peruses the two letters, they have very clearly indicated that there was trust had broken down between the parties, and for such reason they were backing out, and they did not want to continue with this joint venture along with the writ petitioner.
But I have not, my lord, I had issued because they, obviously, my lord, in view of that,
it required hearing.
my lord, only one thing, my lord, kindly takes up page 225.
Correct.
No, the JV partner also writes.
You have a
The
dispute
JV
with
partner, my lord,
the-
right?
How he can continue with the work
My lord,
once you have entered and there
my
is a
lord,
dispute?
my lord,
How you
without
can execute the work? And you have issued the notice under 21 to the respondent number 3 for settlement, but
No, my lord, after 21 notice, since the JV
as
partner,
the JV was
partner,
as the defendant, the respondent number 3 has given a no objection, you continue with the work.
No.
Then
my lord, there was no objection. There was no objection given. My lord,
then
my
once there
tender is subsisting.
you entered into
They
the
have,
tender, you entered into a contract with regard to the JV. Correct?
yes,
JV, you and the respondent number 3.
yes.
The contract was awarded, letter of intent was issued to you. But in the meantime, the respondent number 3 has informed the JV, this respondent number 2, that he was they don't continue with that. So if you are not continue, how they can allow you to
yes, my lord.
continue with us? What not fact? That is a fact.
I'll take you letter.
No, my lord, my lord, finally comes to page
Let the matter appear.
225. My
This
lord,
court
whether
find
JV
that the
writes
matter
to
is
them.
required hearing, but due to paucity time, matter could not be taken of hearing today. Let the matter appear on 23rd June. Next.
And in the meantime, may I file affidavits?
Okay. In the meantime, the respondents are liberty. Respondent number 2 is liberty to file affidavit in opposition. Respondents are liberty to file affidavit in opposition within 2 weeks. Reply if any there to be 2 weeks thereafter.
I'm grateful.
The only thing that by blacklisting,
Affidavit of service, in spite of the service of notice, the respondent number 3 is not appearing. It's not appeared. Let the affidavit of service be kept with the record. Next.
my lord, only thing that by blacklisting is that for 6.
Okay.
My lord, I am appearing on behalf of the petitioner, my lord. Very short cracks of the matter. I do not want
for
to.
the state.
I'm for the Union of Railway.
Who's for the state?
State means, my lord, it's for the railway is a party, CIC is a party.
You are appearing for whom?
Railway, my lord.
Railway, yes.
My lord, very short crux of the matter, my lord. I'm not going to the detailed situation. I am an employee of Eastern Railway. My lord, one inquiry was initiated by the ICC that for under the POSH Act. Now, my lord, thereafter there was finally there was a report. I don't call it a conclusive report, but there was a report that there was 3 issues was decided against me. I mean, out of which 2 have been decided in my favor, and for 3 it was decided like I have said sorry. But what will happen, that was not written. Now, for these, my lord, I have started asking for the firstly complaint. Then I went to the Scheduled Caste Commission because I am a member of the Scheduled Caste. And then they interfered, my lord, and then I was given the copy of the complaint. And then I was not given even a chance to cross-examine because I am the accused, my lord.
When the proceeding has been initiated.
Proceeding has been, my
when
lord.
the proceeding was initiated.
Yes,
when the committee was constituted.
Yes.
By the railway for inquiry of the inner house inquiry.
Yes.
In-house inquiry. In-house inquiry.
Yes, in-house inquiry. My lord, if your lordships kindly comes to page 32, running page 32.
Yes.
This is the first time I was
So you have
given a
received the
notice.
notice of inquiry on 30th March 2024.
Yes,
You have appeared.
yes.
When you appeared.
I immediately appeared, and what I did, my
What
lord,
has happened on 4th/4?
my lord, if your lordship kindly comes to the next following page.
Yeah.
I requested to get me a copy of the complaint because under the rule 7 of
Where? Request to get the copy of the complaint.
on page 33,
So
my
now
lord.
that's why let's come serially. 30th March notice was issued.
Yes.
That the fixing a date on 4th/4/2024 at 14 p.m. What has happened on 4/4?
My lord, there I asked for the copy, my lord. If your lordships kindly, with utmost regards, in response to a letter under reference herein, I would like to inform you that I attended the scheduled inquiry on 4/4/24.
Correct.
I received the above reference letter on 1/4/24.
Correct.
But copy of the complaint letter submitted by Sumati Sanghamitra Adhikari against me through internal complaint was not attached with the letter under reference. This thing started. In that complaint letter, lots of allegations against me were written by Srimati Sanghamitra Adhikari. Then on 4/4/24, attending the scheduled inquiry hearing, I requested earnestly to you to provide a copy of the complaint letter submitted by such against me through internal complaint committee, and I was assured that I will be provided the complaint letter. But till date, I did not get any copy of the complaint letter.
And what has happened after this?
Yes. Well, thereafter, I went to they remain silent. Thereafter, I went to the National Commission for Scheduled Caste for intervention. Well, they have issued one order. This is the order, no? If your lordships kindly comes to page 37.
Yes.
To the head of the office.
Yes. You are requested to submit the facts information.
Petition was
issued the notice.
Yes.
They have issued the notice by fixing the date on 21st of May.
Yes.
No.
But yes, 20 as enclosed, and the commission has decided to investigate into the matter. They have intervened. And finally they said, please look into this matter, because if you don't give the letter of the complaint at the complaint itself, then how I'm supposed to know what is the allegation against me? That was the first area. Then the commissioner does not receive reply. My lord, I'm reading out the last paragraph. Within the stipulated time, the commissioner may exercise the power of this. Then thereafter, my lord, page 38. To the director, they have given that this is from Momita Kundu. This is ICC committee, my lord. They have given a letter to that. During course, my lord, if your lordship kindly comes to para 5. During the course of the inquiry, after examination and cross-examination of Sri Kaushik Das, complainant and witness, the ICC did not find any conspiracy against Sri Kaushik Das. As per norms, ICC submitted their inquiry report, which was forwarded to the controlling office of Sri Kaushik Das on 3rd May 2024. This is for your kind information.
Who?
This is Dr. Momita Kundu, my lord.
So this is internal committee.
ICC, yes.
The internal committee has submitted the report to the National Commission of Scheduled Caste.
On 30th September 2024.
Correct.
I have not received anything. Then thereafter, my lord, I was given a notice by the commission of the Scheduled Caste Commission. I was directed to refer to your presentation to the...
Okay, your notice was
Yes.
issued. Then what has happened?
Yes. My lord, now what has happened, my lord, if your lordships kindly sees the report itself, I will go straight to the report. It starts from page 45, my lord. And the inquiry report is at page 47. My lord, a lot has been written. The conclusion, I go to 48. In the light of the above stated facts and circumstances, only one charge out of the 3 charges, my lord, as I was referring, I started with this, is proved against Sri Kaushik Das. Report is submitted for information and necessary action. Now, my lord, here, in case of an appeal, if it is an order against me, then I have to prefer an appeal. And what is the provision of the appeal? that it has to be recommended. It is from the date of recommendation, my lord. It is being calculated, the
So
period of
what is
90.
the writ petition you filed?
The writ petition, I only wanted.
No, the earlier there was a writ petition.
Yes,
by you.
writ petition is before the schedule cost commission. That thing I filed.
So what has happened to the schedule
So
cost?
that's for that there was an intervention by the schedule cost and commission.
So what has happened in that?
That has been disposed of.
What has happened in that?
That was the only prayer in that writ, my lord, is that.
Array, schedule cost, what the schedule cost has held? You went to the schedule cost.
Yes, yes.
You made a complaint. Schedule cost was not taken up the matter. You came to this court. This court has passed the direction to come to dispose of your case.
Yes.
So what has happened before the schedule cost tribunal? You persons are not getting ready.
My lord.
It is fine that the petition not ready with the brief. Let the matter appear in the month of July.
My lord, after the summer, my lord.
You persons are
I'm sorry, my lord.
This matter was taken up yesterday. Lordship wanted me to once again serve the respondent numbers 13 and 14.
Yes.
My lord, I have served, my lord. This is the affidavit of service. My lord, my challenge was very limited. My lord, this is, my lord, an tender called for installation of a planetarium. My lord, tender conditions, if your lordship kindly comes to page 49, my lord.
49.
49. It starts at page 47, my lord, where the timelines are given.
What is the tender for?
My lord, this tender is for installation of Meghnad Shah Planetarium. My lord, it's kind of, my lord, those, my lord, 3D, my lord, systems, my lord, which we have similar to, my lord.
Projector and software, both part.
Then
The my lord kindly comes to clause 4.2 at page 49.
4.2.
Yes.
Bidder
must have the experience of implementing 2D full dome immersive projection system. Bidder must be an original manufacturer of digital or hybrid full dome system software or an authorized agent, partner of OEM. OEM is, my lord, original equipment manufacturer of a hybrid full dome system software. Bidder should be either OEM of optomechanical planetarium system. I'm sorry, my lord.
Original equipment manufacturer.
Original equipment manufacturer.
Okay. Yes.
Then also bidder should be either OEM of optomechanical planetarium system or authorized agent of the OEM of optomechanical planetarium system. Well, the next sentence is important. In case the bidder is an authorized agent of the manufacturer, then authorization letter from OEM must be furnished with all the details. Well, this makes it clear that either my lord, original
manufacturer or the
authorized agent. Now, my lord, kindly comes to 4.4. If the OEM is outside India, then they must have an authorized agent in India. In this case, my lord, OEM is outside India, respondent number 15. The authorized agent must have experience of installation and integration of multi-channel, full dome, digital and optomechanical projection system in India during the last 5 years. So, my lord, the point I am trying to make here from 4.2 and 4.4 is that an OEM can have only one authorized agent in India who can participate in the bid. In the present case, the OEM is respondent number 15. OEM has authorized respondent number 13 also, respondent number 14 also, same OEM, to participate in the bid. Now, both of them have submitted technical bids and financial bids. And, my lord, along with me, which is, my lord, the petitioner. Technical bid at the technical, my lord, evaluation stage, petitioner, respondent number 13 and respondent number 14 were successful. Then, my lord, it came to the financial bid stage, which, my lord, I learned from yesterday that financial bid has been opened. Now, my lord, the other interesting feature is, my lord, kindly sees the, my lord, pro forma of the authorization letter, which is at page 90 of the petition. This is how, my lord, the authorization has to be filed.
Page number?
90, my lord. 90.
This is the format.
This is the format.
Yes.
We hereby state that the product offered vide this tender by our authorized agent. The expression used is our authorized agent.
Yes.
So, my lord, even in the clause in the NIT as well as in the pro forma, it implies that there has to be one authorized agent who can be authorized by one OEM.
Under the word tender, our authorization.
The clause says an authorized agent, the pro forma says our authorized agent. One last clause, my lord, disqualification clause, which is at page 58. If there is any.
What do you want to say from the
My lord,
90?
from page, from the two clauses I referred and page 90, my argument is that an OEM, and my lord, equipment manufacturer outside India can only have one agent in India who can participate in the bid. There cannot be, my lord, multiple bids submitted by the agent representing one single OEM. My lord, kindly visualize the situation. If this OEM is of Germany, my lord, he, my lord, produces, my lord, or he allows 10, my lord, bidders to participate in this bid. Ultimately, the equipment would be coming from, my lord, this OEM who is, my lord, the person situated outside India. So he is trying to, my lord, create a cartel here for the purpose of securing the bid. My lord, in this case, it is 2, but I am giving your lordship a situation where, my lord, it could have been more than 2. To, my lord, understand that how the cartelization is being done. My lord, this is something which, my lord, the tender
How you say
conditions.
the cartelization?
My lord, because, my lord, the expression used is an authorized agent in 4.4. Lordship comes back to 4.4 once at page 49.
Yes, I am there.
If the OEM is outside India, then they must have an authorized agent. So it is a singular authorized agent who can, my lord, participate. Otherwise, the expression would have been authorized agents in India. And, my lord, it would have, my lord, permitted any authorized agent under that OEM to participate in this tender process. This is not what is envisaged under the tender conditions.
And the 90?
90, my lord, it says our authorized agent. That also, my lord, implies that there is a singular authorized agent of a singular OEM. It cannot be more than one, my lord. In this case, my lord, the same authorized agent, my lord, has, my lord, allowed bids to be submitted. This is one angle of the cartelization, my lord, theory. My lord, the other is, my lord, kindly comes to, my lord, the documents which have been, my lord, uploaded. I would show that there is, my lord, even respondent number 13 and 14 are same entities or at least controlled by same person. My lord, the respondent number 13's bid starts at page 94. Kindly comes to page 94.
Yes.
My lord, the authorization letter given by the OEM to the respondent number 2 is at page 282. 282 should be, my lord, volume 2. Yes, my lord. এটার সাথে অন্য authorization letter টা বার কর।
Yes.
My lord, this is written, my lord has got to it, my lord. This has been, my lord, issued by Skyscan, which is, my lord, respondent 15. Kindly see who is signing it. Glenn Smith, CEO and Managing Director of Skyscan International so-and-so. My lord, a German entity. We, Skyscan International so-and-so, hereby state that the product offered with this tender by our authorized agent, Messrs. Deep Sky Private Limited, which is R13, my lord, respondent number 13. And to be supplied, if found suitable and selected, shall be our original equipment and software, and is to be deemed as if the supply has been made by us directly. This is one authorization letter. Now, my lord, kindly sees, my lord, side by side, page 414, my lord, which is, my lord, volume 3.
Yes.
My lord, again sees who is, my lord, issuing the letter. Skyscan, signed by the same gentleman, Glenn Smith, CEO and Managing Director. We, Skyscan, hereby state that the product offered bid this tender by one of our authorized agent for Meghnad Planetarium project, Messrs. Cosmos Engineering. This is, my lord, R14. And to be supplied, if found suitable and selected, shall be our original equipment and software, and is to be deemed as if the supply has been made by us directly. So it is, my lord, the point, my lord, this is the only 2 points I have. My lord, if lordship is with me, my lord. 4.2 read with 4.4, and the pro forma of the authorization says that it can be only one authorized agent of OEM. The authorization letters, my lord, say that Respondent number 15 is authorizing R13, R14, and my lord, this process could have been continued with other entities also who could have participated. This is creating a cartel, my lord, at the instance of R13, R14, and R15, who are ensuring that this, my lord, process once fructified would, my lord, fructify into an award of contract in favor of either of them. My lord, I have also disclosed, my lord, one document, which is, my lord, page 529, my lord, at volume 4 of the, my lord, writ petition, where the respondent number 15 is disclosing only one authorized agent in the website. My lord, page 529. My lord, sees at the, my lord, foot of the page, second last bullet. In India, their authorized agent name is Deep Sky Planetarium Private Limited, which is R13. So, my lord, an incorrect statement made, my lord, in a bid is also, my lord, shall, my lord, disqualify a bid. That is, my lord, clause 12 of the, my lord, tender conditions, which lordship will find at page 58.
Page 58.
Page 58, my lord, clause 12. During the scrutiny, if it comes to the notice to tender inviting authority that credential or any other paper found incorrect, manufactured, it's incorrect, that bidder, vendor, contractor would not allow to participate in the tender, application will be rejected without any prejudice.
Which clause you are reading?
My lord, clause 12 at
During
page
its scrutiny.
58 of the, my lord, writ petition.
Yes.
And one last clause, my lord, clause 33 at page 67. Page 67, my lord, clause 33.
53.
Yes, my lord.
Page 67.
Yes, my lord.
Page 67 clause
33, my lord. Third clause at, my lord, at this page, 33. Even though the bidders meet the above qualifying criteria, they are subject to be disqualified if they have made misleading or false representation in the form, statements, and attachments. So the website of R15 is saying Indian agent is R13. Authorization letters are, my lord, shown by R13 and R14 to be, my lord, authorized agents of R15. My lord, the tender conditions say only one authorized agent can participate of the OEM.
Okay. Yes.
My lord,
But
last,
your
my lord, last contention. My lord, that is, my lord, one gentleman, Kamal Sethia, who is a director and a minority shareholder in R13, and also, my lord, the person, the authorized signatory in R14. So R13 and R14 are, my lord, entities which are being controlled by the same person, my lord.
Where is
My lord,
where you can
my
say?
lord, kindly comes to, my lord, volume 4, page 505. My lord, first, this document would show that Kamal Singh Sethia used to be, my lord, a director of Cosmos Engineering, which is respondent number 14. Lordship will find the period also mentioned. Lordship has 506.
The period is important. Yes, 17, 18, 87,
87 to 2016. Now, my lord, kindly comes to next page. For Deep Sky Private Limited, he was, my lord, a director from 2005 to 2007, which is again, my lord, an intervening period between the, my lord, between 87 to 2016.
Page?
My lord, next page only. 506, 505 I showed. Now 506, my lord, this is for, my lord,
Deep Sky.
Deep Sky. The period is from 2005 to
2007.
Yes. So there is one common period when this gentleman, Mr. Sethia, was director of both the companies.
Correct.
Now, my lord, so far as R14's bid is concerned, kindly comes to, my lord, page 333 at volume 3 of the writ petition. This gentleman, Kamal Sethia, has been made the authorized signatory. My lord, page 333, volume 3.
Submission of digital full done.
My lord, director Kamal Sethia, I showed he was from, my lord, 87 till 2016. But this document is being signed on 13th March 2026. Who is signing it? Kamal Sethia as the authorized signatory of R13,
Cosmos.
R14.
Cosmos.
Cosmos. Though he is not a director, he is a director, he was a director, my lord, till 2016. He is again being authorized to sign, my lord, this document which is being submitted with the, my lord, tender inviting authority. And his authorization is at page 337.
So this Kamal Setia is the authorized signatory of Cosmos.
Yes.
Correct.
Now, who is,
But
my lord?
as per that document, he was not the authorized
He
signatory.
was a director till 2016.
Okay.
He was a director in that company till 2016. So why an outsider is being authorized? Now kindly comes to, my lord, page 337. I am only trying to, my lord, demonstrate the influence this gentleman has in the two entities. My lord, 337, annexure 2. This is, my lord, the authority letter by which Kamal Setia is being authorized. We do hereby authorize Mr. Kamal Setia, authorized signatory.
Now the answering respondent is the foreign whether notice is served.
Yes, email lordship wanted me, I have.
When it was served.
My lord, lordship, I only got one more
What
day.
can be done? Unless it is because it is between these three persons, how this court can interfere at this stage?
My lord, if lordship is
And when the bid
on
is
a prima facie, my lord,
very high.
consideration. No, my lord,
The bid is
no, that is
1 crore 26, and I got it.
I
for
will,
not-
my lord, I will interject Mr. Mukherjee for 2 more minutes. My lord, I have presented a challenge before the court. The business of the court has not, my lord, allowed the petition to be heard on a particular day. On that day, the financial bid was not opened. So possibly Mr. Mukherjee could not have taken this as a ground. Now, lordship would be, I am trying to persuade your lordship to consider the challenge on the date when it was presented.
No,
And my lord, if
is
I can,
different thing. That is different thing. Not the court is now as per.
I understand presence of
R13, 14, 15. They are in connivance. As per your case, they
Yes,
are in connivance.
exactly.
Correct.
Yes.
And if maximum will go, 15 is the maximum, it will go 15 and 13 is the connected one.
15 is connected with 13, 15 is connected with 14.
No, 14 with regard to how he has come the third.
Yes.
So that is the question. So that answer is to be given by the 15 only.
My lord, if
And how the
lordship is
court
prima facie, my lord,
No, how the
even if your lordship feels, my lord,
how the court can enter into that?
no, my lord, court can enter into this issue only if court feels that, my lord, there is some, my lord, semblance of, my lord. My lord, I know our lordship is, my lord, short of time today.
Not short
I
of
was,
time. I will give the time, no problem. But this is a tender process. It is the authority has to decide because they have to issue the tender. The court, you know that it is settled law.
my lord,
Yes,
I had
the
given
court-
the objection to
court
the
can
authority.
enter into the contractual matter if there is an arbitrary on the part of the authority. It is not your case with the authority have done something.
No,
It
of
is-
course, my lord, my challenge is against the authority.
it is with regard to if the authority suppose I am also the dealer of the Philips, you are also, because Philips company is not giving the dealership to one company or Orient company, whatever one company. He is giving to several persons as an agent. And the government has put the tender.
Very apt example. I got it. Lordship need not, my lord, add further. But only distinction. Only distinct, because when I was drafting the writ petition, I had something like this in mind. But, my lord, the expression used in 4.4, it says an authorized agent.
Correct. Unauthorized agent. Unauthorized agent means it is not that he should be only one authorized agent. It is not that it is only one authorized agent. The company, you cannot restrict or court
My lord,
cannot restrict or
there is a my lord, there is a consequence to this. If a OEM wants, he can sabotage our entire tender process. Kindly, my lord, try and visualize this from this angle, my lord.
If that authorization, 13 and 14 jointly have an authorization, the court can go into it is a jointly, it is not an, but it is separately authorization.
But same persons who are in control, my lord, same Mr. Setia is being, my lord, authorized. My lord, this is
you know in the contract term there is a term which if a big contract has been issued, so all the contractor will come together.
Yes, but at times.
Correct. So that the bid should not go outside. So and they will manage amongst them.
But I was only carrying one, my lord, I was carrying only one judgment, but this was on collusive tendering, my lord. This is what I was, my lord, trying.
Collusive with the other, but here
This is the authority knows everything. The authority
how
has
do I
the,
know, Lord?
no,
I
the
got to go
authority,
by the
my lord,
documents.
authority is only
I've
scrutinizing the
not
documents.
done the
the
research
court
that my
cannot
learned friend has done
direct
in
the
his paper.
authority to stop this and inquire whether both are, and that can at the in the tender stage.
No,
And
the authority has all the documents.
with regard
Authority
to-
will evaluate. The committee is there.
And with regard
This
to
is
the
not even an
document,
essential
and
qualification
with
at all
regard
what
to
my
the
learned friend
document
said.
which you relied upon, page 529, Deep Sky is the only agent
Yes.
in India.
Yes.
Correct. Nowadays, you know, every
Deep Sky
time.
is L1.
Huh?
Deep Sky is L1 and he is L3.
Then
And the difference is 10 lakhs between the L1 and L2.
That is neither here nor there. I don't know why Mr. Mukherjee is arguing this. Well, it's a
Because
prejudice
the
point.
equipment comes from the same company.
If it a Deep Sky is L1 and you are harping of 529, so where is the, if we go to the other person, then we can say that.
No, it is not that only, my lord, L1 or Deep Sky had participated as an agent of the, my lord, R15. Had that been the case, possibly what your lordship is saying, I would not have an answer to that. My lord, Deep Sky and Cosmos both have been, my lord, authorized by.
Correct. Authorized. But now they have separately. Now the authority is not going to.
My lord, if the issue of work order, now that the financial bid has been opened, my lord, this, my lord, the lordship understands when a tender writ petition, nothing survives, my lord, if a work order is issued.
That's why, you know, since when I have taken the determination, if the tender matter comes, I am not keeping any affidavit. Very day I am disposing of either this way or that way. Because keeping the pending in the tender matter is no
This is
purpose
almost blood in the nature of an infrastructure project.
Correct.
There, blood. And
either this way or that way. Even what can be done?
Only for the sake of completion, I know.
Yes, you no problem.
Like this is reported in 2017 at a copy there. 2017 8 SCC 47. Only para 51. my lord. On collusive tendering.
Yes.
Lordship may take judicial notice of 50 and 51 only. 50 and 51.
Settle principle. Settle principle. No, not that, but settle.
2000 এটা নিয়ে নাও না আমার কাছে কত
তোরা কেন বলছিস ফিনান্সিয়াল ব্যাংক তোদের চিঠিতেই লেখা আছে তোরা ফিনান্সিয়ালটা
Yes.
I'll rest it there.
Yes, Mr. Mukherjee.
Minority shareholder.
Your lordship will kindly come to Lord the paragraph which my learned friend has relied at page 49.
42, 44.
Yes,
4.2,
4.2 and Lord, here, Lord, the original equipment manufacturer, as it fell from your lordship, is Lord who manufactures Lord the hardware and the software portion. Now, Lord, they might be supplying to Lord the agents. The bid comes from the agent, not from the OEMs. Therefore, Lord, the OEM might be selling his product, but Lord, ultimately, my client, the purchaser, the university, is getting the benefit of Lord the bids to the agents. So, Lord, my learned friend's contention that there should be one agent per OEM, as per Lord, the reading of 4.2 and 4.4 is not incorrect in my respectful submission. Now, Lord, so far I'm a bit brief. Lord, I can elaborate if your lordship so wants, Lord,
No,
that
brief,
by
brief.
reading
You
Lord
give
these provisions, Lord. So far as Lord the collusion, so far as Lord the authorized Lord the person who is entitled to Lord put in the bid, and they were trying to show there is a Lord an element of commonality between the directors at one point of time, and therefore Lord the Cosmos and Lord the Blue Sky, they are in fact a one entity. It is their contention.
Yes.
Your lordship has seen Lord the period when one of the parties were a director.
Yes.
And Lord the extent of it, Lord the shareholding in the company is 1%. I can show from the documents my learned friend has annexed. Therefore, Lord, as of today, Lord, the key managerial person or Lord, the shareholder or the director, Lord, does not take, Lord, I mean to say the shareholder doesn't take any decision on, Lord, how the company runs. And he is not, Lord, the director as of today. Lord, that Mr. Sethi.
Yes.
Kamal Sethi. So, Lord, as of today, since he is not the director of Lord any of the companies, Lord, it doesn't matter, Lord, whether Lord he has at past, Lord, he was a director or not. So, Lord, there is no question of collusion in that respect. Now, Lord, the question of opening of the financial bid, as my learned friend says that he has come to know now, your lordship will find in the representation to my client, my lord, they have already stated that after opening of the technical bid, my lord, the financial bids were open because only there were 3 bidders. Of all the 3 bidders, 3 were qualified technically. So, my lord, on the score of technical evaluation, my lord, 3 are qualified. Post, my lord, opening of the financial bid, my lord, they take out, my lord, these 2 points about the collusion. My lord, the difference I've already noted, my lord, and my lord, it is for the orbit animate, the petitioner, it is 1 crore 26. It is for the Cosmos, the my lord, the second my lord, highest bidder, I must say. My lord, it is 90 crores. And my lord, for the deep sky, my lord, 90 crores, my lord, I'm not giving my lord the other my lord, the broken figures, my lord, it is rounded
That is
off.
the one, the petition is 120.
126.
Yes.
126. 1 crore 26 lakhs. And my lord, for the deep sky, the respondent number 13, who is the lowest, is my lord, around 79 lakh 50,000.
No, this Cosmos is 90 lakhs.
90 lakhs. Yes.
90 lakhs, not crore.
No, 90 lakhs.
That's why.
Yes. I said crore. Oh, I'm so sorry, my lord.
90 lakhs. And the other is?
Other is 1 crore 26 lakh. That is, my lord, the orbit, the petitioner. And deep sky is, my lord, 79 lakh 44,000.
79?
44.
44.
My lord, this is the difference, my lord. They are way ahead, my lord, with their court financial. That's all from the
My lord, in reply, only one point, the others I have already addressed. Mr. Mukherjee's argument that or contention that after coming to know the result of the financial bid, I have taken this point. This is not evident from the letter which has been issued, my lord, prior to the institution of the writ petition. My lord, even today, my lord, when we tried to, my lord, see whether the financial, my lord, from our end, from the bidder's end, it's not visible. Maybe from the, my lord, tender inviting authorities end, it's visible. But from our end, when we do it, my lord, online, we can't see. So that is why, my lord, Mr. Mukherjee gave your lordship this information. Who has, my lord? We were doing it, my lord, and my lord, the
541.
My lord, result shows opening, financial bid opening in progress. So I have this only, my lord, even as on date. Not that after coming to know, I have, my lord, made this as a ground of challenge. My lord, that's all, my lord.
I just want the documentation of a separate tender. It is in respect of Nehru Science Center, where the OEM was on Christie digital system, where the authorized agent is my client also as well as the petitioner's client. So it is not, my lord, that any cartelization is happening. It's respect of a separate tender. I can show place this one.
I don't know tender. What are the tender conditions in that tender? Well, how can we, my lord, vouch for that, my lord, without knowing the NIT?
That, acha. Christie Digital, you have down participated. What you are appearing for? You are appearing for?
I am appearing for only respondent number 30. Private respondent number 30.
Who? Cosmos?
Deep Sky.
Deep Sky. So what is your?
In respect of that, my lord, that since my next friend has raised the point of cartelization, my lord, there was another tender floated in respect of Nehru Science Center, my lord, for similar kind of project.
Achha, the petition and both have appeared.
Yes, they are, my lord.
So they cannot challenge that. No, he is not telling that you cannot. He is telling that, okay, the Deep Sky, so both the persons, a common person.
Yes, that I have answered. My lord, he was admittedly our director, but that was 2007. And shareholder, only 1% shareholder, my lord, that was 2022. 16th of May 2020, not after.
Director till?
16th of May 2022. I have
16 May 2022. And shareholder?
Shareholder till 16th May 2022.
Holder of 1%. Shareholder of?
Shareholder of respondent number 13.
1%.
Yes.
How many? What percent of the shareholding?
I'm sorry. Yes.
It's 1%.
1%.
1%.
Balance sheet, it shows it's 1%.
Okay. That's all. Anything further?
My lord, 1 minute, my lord, only to deal with his argument. Kindly takes note of, my lord, page 521, which is balance sheet as at 31st March 2025. My learned friend said shareholder of 1% till 2022. That is wrong. Their own balance sheet of 2025, year ending March 2025 shows that, my lord. 521, clause E. shares held by promoters at the end of the year. Well, the second name Kamal Setia. It's their balance, their financial document they have disclosed before the tender inviting authority.
Just a minute. Yes. So
Malad
1%, Kamal Setia.
Kamal Setia, number of shares 10, it's 1%.
Ah.
Yes. So it's not 2022 till 2025, year ending March 2025. This is the position. Now this comes. This declaration is not there before the tender inviting authority. Now when I take it as a ground, this comes.
In any event, the tender was in 2026.
2020?
2026, March.
Okay. The petitioner has filed the present writ application. Okay. Praying for. What is the prayer?
Page 40, my lord.
Bring for a direction upon the respondent authorities, respondent authorities to cancel, revoke, or resign the bids submitted by the respondent number 13 and 14, being authorized agent in India of the respondent number 15, in connection with tender number MSP/tender/001 issued 001 dated 23rd of February 2026. The University of Bardhaman has issued a tender notice for Meghnad Saha for installation of Meghnad Saha Planetarium, Golab Bagh, Bardhaman. The petitioner has participated in the said tender. After participating in the said tender, the petitioner also came to know that the respondent number 13 and 14 has also participated in the said tender, being the authorized agent of the respondent number 15. The contention of the petitioner in the contention of the petitioner is that as per the document, the Piskai is respondent number
13.
The respondent number 13 is the only authorized agent of the respondent number 15 in India. But the respondent number 14 has also participated in the said tender, being the authorized agent of the respondent number 13 and 15. Learned Mr. Datta, learned advocate appearing for the petitioner submits that the respondent number 13 and Mr. Kamal Singh Setia is the director of both the companies, and as such there is a connivance between the respondent number 13 and 14. The petitioner has relied upon clause 4.2 and 4.4 of the tender document and submits that as per the 4.2 of the tender document, the bidder must have experience of implementing 2D full dome impression projection system, and the bidder must be an original manufacturer of the digital / hybrid full dome system software of an authorized agent / partner of OEM within bracket original equipment manufacturer of hybrid full dome system software. By referring clause 4.4 of the tender document, the petitioner submits that OEM, if the OEM is outside India, then they must have an authorized agent. An authorized ko na usme karo item. An authorized agent in India.
Full stop. By referring full stop, the contention of the petitioner is that in terms of clause 4.4 of the tender document, only the OEM should an authorized agent, not two. But in the present case, the respondent number 13 and 14 both are the authorized agent of the OEM in India. Thus, the respondent number 2 and 3 have violated and thus the participation of the respondent number 2 and 3 is in violation of clause 4.4 of the tender document. The petitioner has also pointed out the format of the authorization, which is Annexure 8 of the tender document appearing in page 19 in the present writ petition. He submits that in the said performa of authorization, it is mentioned that our authorized agent, but the same authorization has also been given to the respondent number 13 also. But the said authorization letter has been given by the respondent number 15 to the respondent number 13 as well as respondent number 14. Full stop. Learned counsel for the petitioner further submits that the respondent number 13 Deep Sky Planetarium Private Limited, as per the balance sheet of the respondent number 13, it reflects that Kamal Sethia is the shareholder of the respondent number 13, having 1% share in the said company. And thus such that this document also proves that the respondent number 13 and 14 are in connivance. Full stop. Any further? The petitioner has relied upon the judgment in the case of Excel Corporation Corp Care Limited versus Competition Commission of India and another, reported in 2017 volume 8 SCC 47, and submits that the Honorable Supreme Court has held that the collusive tendering takes many forms. Simplest form is to agree to quote identical price with the hope that all will receive their fair share of orders. Full stop. By referring the said judgment, counsel for the petition submit that the respondent number 13 and 14 have in connivance have participated in said tender so that the third party cannot get the benefit of the said tender. Full stop. Learned counsel appearing for the Mr. What the response, Mr.
1 to 12.
1 to 12.
Lordship.
1 to 12 submits that
2 to 12. I'm sorry. 2
to 12 submits that clause 4.2 provides that if the OEM is outside of India, then he must have an authorized agent. That does not mean the OEM should only having one authorized agent in India. There is every possibility that the OEM may give authorization to many of the persons, many of the firms. Thus, the full stop. The counsel for the petitioner for the counsel for the respondent number 2 to 12 further submits that after opening of the technical bid, it is found that the name counsel for the respondent number 2 to 12 submit that altogether 3 firms have participated in the said tender, including the petitioner, that is the petitioner, respondent number 12 and 13 and respondent number 14. On opening of the technical bid, it was found that all the 3 firms have qualified for the technical bid. and accordingly the financial bid was open, and after the opening of the financial bid, it was found that the respondent number 13 is the lowest bidder, and the petitioner number 1 is the L3. Petitioner is the L3. Accordingly, the respondents have accepted the tender of the respondent number 13. Respondent number 13. He further submit the full list. Learned counsel for the respondent number 13 further submit that only because of two of the firms are the agent of the one manufacturer who have participated in the tender cannot be said to be a cannot be said to be in collusion. As per the tender document, the firm who are participating in the said tender has to submit the document, and as per the document, the respondent authorities have satisfied that both the firms were having the authorization from the respondent number 15, and accordingly the tender document of the respondent number 13 was accepted as he was the L1 bidder. Learned counsel appearing for the respondent number 13 submits that the petitioner had the knowledge that the respondent number 13 is the authorized agent of the respondent number 15. In another tender issued by the Nehru Science Center, the respondent number 13 has participated in the said tender, being the authorized agent of Christie Digital System. Now the petitioner cannot say that the respondent number 13 and 14 are having the collusion with the respondent number 15. Having collusion with each other. Had the learned counsel for the respective parties peruse the materials on record. Material on record. The contention of the petitioner that as per clause 4.4, if the OEM is outside of India, they must have an authorized agent. But in the present case, the respondent number 3, who is the OEM, has given the authorization to two authorized persons, two firms, that is the respondent number 13 and 14. In support of his submission to prove that respondent number 13 and 14 are in collusion and the tender documents submitted by the respondent number 13 or 14 are in violation of clause 4.0, has relied upon the Ministry of the document received obtained from the website of the Ministry of Corporate Affairs, wherein it is wherein one Mr. Kamal Singh Sethia was the director of what is the firm? Cosmos Engineering, director of the respondent number 13 from 14, respondent number 14 from June to 1987 to 14 December 2016, and the said Kamal Singh Sethia was the director of the respondent number 13 from 2nd November 2005 to 12th of June 2007. The petitioner also relied upon the balance sheet of 2024-2025, wherein also where is the balance sheet?
That is
Balance sheet
21.
Balance sheet of respondent number 13, wherein it is found that the Kamal Sethia is having the 10 numbers of share, having 1%, and thus that is also proved that the petitioner, the respondent number 13 and 14 are in collusion. Per contra Leonard full stop. The respondent number 13 submits that the respondent number 13 was the shareholder of was the director of the respondent number 13 till the year 2022. Thereafter he was
Director till 2013, 2007, and shareholder till
no, was the director till 13 June 2007. 2007 and and was shareholder till 16th May 2022. And thereafter there is no relationship between the respondent number 14. This court finds that the balance sheet which the petitioner has relied upon is of 2024-2025. 2024 or 2025. But the tender document is issued in the month of
February 2026.
February 2026. Thus 2026. Considering the above, this full stop. This court, considering the above, this court find that this court find that Kamal Singh Sethia was the director of Cosmo of the respondent number 14 only till the year 2016 and was the director of the respondent number 13 till 12th of June 2007. So there is no document to say that still the respondent number 13, Kulwant Singh Sethia, was the director of both the company as on date of publication of the tender document. The balance sheet which the petitioner has relied upon, that also does not say that does not say that on 2026 the Kulwant Singh was having the share holding in the said company. And it is the specific case of the respondent number 13 that the shareholding was only till 2022. And thereafter, the Kulwant Singh Sethia was not the shareholding of the Cosmos, of the Deep Sky. Full stop. Full stop. Considering the above contention of the full stop, considering the above, this court find that the petitioner has participated in the said tender along with the respondent number 13 and 14. Only the contention that the respondent number 13 and 14 were having the collusion. But the documents which the petitioner has relied upon, this court is not satisfied that from the said document it can be proved that there is a collusive, there is any collusion between the respondent number 13 and 14. As regard the contention that in terms of clause 4.4, the OEM who is the outside, if the OEM is outside India, then he must only have one authorized agent. That also cannot be said to be correct. One OEM cannot none of the parties can restrict any of the OEM to only having one authorized agent. It is the company to decide how many agents can be appointed in one area. In the present case, the respondent number 13 has appointed the respondent number 13 and 14 as the agent of the respondent number 15, and as such, this court is not able to accept the contention of the petitioner. Considering the above, this court did not find any justification to interfere with the tender process initiated by the petitioner, initiated by the respondent number 2 to 12, wherein it is also find that the tender process is, wherein it is also find that the respondent number 30 is the L1, and the respondent and the petitioner has quoted is the L3. Considering the above, writ petition is disposed.
Agreed. Grateful.
Sorry.
Apologies, my lord, to keep
Sorry.
your lordship waiting, my lord. Apologies to keep your lordship waiting during the, my lord, lunch hours.
I would not have prayed this, my lord, only difficulty. I understand, my lord, from Monday difficulty, if it goes to a different court, my lord, your lordship will not be available. We may require to re-argue the matter, my lord.
I appreciate Mr. Tiwari is appearing in all days in this situation.
But he always accommodates everybody, my lord.
Yes. Which number?
But it's 109, my lord.
You are appearing?
Yes, 109.
Give.
My lord, Mr. Arjit Chakravarti is appearing for the Enforcement Directorate. Kindly take this matter at after 3 p.m.
After
3 p.m. my civil original. Come before 2:45. 2:45. Before 3. Before 3, 2:45. After 30 minutes.
2:45. Most obliged, my lord. Deeply obliged, my lord.
Yes, call the list.
My lord, my writ petition, my lord. I've served, everyone has received it.
Item number?
My lord, this is a writ petition, my lord, directed against the respondents for blacklisting or banning.
Who is the other authority?
My lord, authority is the, my lord, Director, Electrical Engineer, Ministry of Railways.
Railway.
All railway. All railway.
Yes.
And everyone has been served. This is the affidavit of service. My lord, I am challenging the blacklisting or banning on 4 counts, my lord. First, my lord, it's a stale charge. My lord, I'll demonstrate the alleged incident occurred in the year 2013. My lord, number 2, my lord, documents were never given to us. Perhaps no documents were relied on because the order is a one-line order. It's a non-speaking order. And number 4, it's a violation of natural justice. Lordship, I'll demonstrate, my lord.
But the other side is not there. What can be done?
My lord, what can be done is, my lord, we had filed challenging the blacklisting writ petition. Lordship will only come to page 95. We had withdrawn this because, my lord, we are suffering. We cannot participate in any future tender.
95.
Yes, page 95. My lord had given us liberty to withdraw and file afresh, my lord. My lord, we are not permitted to, my lord, participate in any further future, my lord, tenders, my lord. My lord, we are a successful tenderer, my lord, who have participated and completed. Page 89, my lord, at least, my lord, 75 agreements, work orders we have completed, my lord, mainly with the railways, the respondents. And we are still working in some present sum. My lord, what I was seeking, my lord, since the other side is not there, there could be a limited stay, my lord, and let us come back when you are.
Where is the impugned order?
My lord, impugned order, lordship will kindly see. It's an order of December 25. December 25, my lord, page 34 is the recommendation and page 37 is the order. Lordship will kindly come to page 37, the order.
Banning of business dealing.
This is the order.
Dynamic service.
Absolutely non-speaking, my lord. Not a single reasoning given. And what they dependent on, my lord, if I might just narrate the facts very briefly.
So you are not given the reply.
My lord,
you are not given the reply. Can
that because, my lord, incident 2013. They started this proceeding in 2025.
Where is the notice issued to you? A memorandum of statement of imputation of charges? Where is that?
My lord, that is it. My lord, page 28 to 30.
Proposal for banning.
Yes. Lordship will kindly see one paragraph first.
Advised to submit the representatives against the action of the. Where is
My
the
lord,
charge?
Lordship will come to paragraph 3.
Paragraph 3 of page.
My lord, page 3 of the writ petition.
No, let the.
Sometimes in 26/9/2013, a tender was floated. My lord, I participated. I was not successful. The allegation is that I had given credentials which were forged. Now, my lord, when they sought for a feedback with the concerned Department of Army, my lord, সেই রিপোর্টটা কোথায় আছে রে? হ্যাঁ? হ্যাঁ। Skill and certificate. My lord,
Lordship will kindly see the first order.
Is there any criminal case initiated against the
No, my lord, nothing.
forgery of the document?
In fact, I've done 75 works. I've shown.
No. The page 30.
Yes.
Against SS Gill Captain so and so, commanding officer had sent a letter by speed post, verification of the genuine certificate in the response of so and so. It is once again intimated that the said firm may have forged the said certificate. The signature in the document attached is not of any officer or the individual present in the depot. The firm has never involved such high value contact anywhere in the unit.
Lordship will come to previous page. My lord, they had sought instructions from the army department, page 29. My lord, third paragraph, confirmation of the genuineness of the to whom it may concern certificate, which had given in support of my credential.
Correct.
My lord, in response, senior DE, Captain Major DSO, Kolkata has sent a letter on 27/11/2013 in which he confirmed that that the work completion credential certificate issued to Dynamic Services, which is the petitioner before your lordship, for the above said work in our different location during the year are true and genuine.
Correct. So
and there are two other which says that may be forged. Maybe. Kindly see, come to the next page. Second paragraph.
The firm may have forged the said.
It is once again intimated that this said firm may have forged.
No, how many certificate is under was under scrutiny?
Malad, they sought instructions from the army. 3 certificates came. 3 feedbacks came. One said, I have done the job and my certificate of credential is genuine. And 2 have said that could be forged or fudged. But these are all, my lord, the dates are all 2013. My lord, when they took up this matter, my lord, for consideration, for blacklisting me, we do not know whether these people were at all called. I was not given an intimation that these documents, these certificates were never handed over to me. I was not given an opportunity to cross-examine them. And this is all happening after 12 years. There is, my lord, lordship, one more document I'll show to your lordship.
You have not given the reply to this.
Well, that because there was a change of address. In 2013, we were somewhere else. In 2025, we were somewhere else.
The document was not served to you.
Not communicated. Lordship will kindly come to page 27. My lord, the issuance, it is dated 2015.
Correct.
During vigilance inspection, submitted forged document. It is advised take appropriate action. My lord, who signs it? My lord, Pradeep Kumar Mohanty, dated 18/3/25, who is the Upo Mukhya Sartakarta Odhikari.
Yes, vigilance officer.
He is a vigilance officer.
Correct.
Now, lordship comes to page 31. My lord, letter dated 17/8/2015.
Monty.
My lord, administrative officer. It is advised that the contract agreement with Dynamic Services Kolkata may be dealt accordingly. He says it is found that Messrs. Dynamic Services have successfully completed the work, housekeeping, gardening, garbage collection and disposal, and the certificate issued by them is true and genuine. And the same person signs it. My lord, in spite of this certificate, my lord, on the same date, my lord, the notice is issued, my lord. Page 28, Chief Electrical Inspector. Now, my lord, after 10 years, in between 10 years, nothing has happened, my lord. Nothing has happened. And I have shown your lordship the order of banning. It's a one-line order, my lord. My lord, there are judgments to show, my lord, that, my lord, it should be a speaking order, judgment. And lordship will once again come to 89, page 89. Page 89.
Yes, page 37 is the banning order.
Page 37 is the banning order.
Banning order.
Yes.
So banning order has been passed. That's why the statement, you have not given any reply. What the authority will do? This was communicated to you on 8th of August 2025. Page 28. Page 28.
It was given at an address where we were not there. And thereafter, if your lordship sees, we had sent representations to them seeking a hearing, and we were there at Delhi at the rail board
We waited for the whole day, but because reasons best known to them, we were not called for the hearing.
So how you got the page 37 order? Page 37 with the impugned order, where, how you got that? Page 37 also the same address.
Mala RTI, we issued, we wrote RTI letters.
Where is the RTI?
Mala page 36.
That is not the RTI.
Mala page 36 is the RTI reply.
No. No, it is not the RTI.
Yes, Mala.
With reference railway board letters and details of the business lane Dakshindari at the division below. It's a D, it is the internal document, not to you.
Yes.
Filed an RTI appeal and page 63, page 63.
Page 63.
Page 63.
Lordship will come to page 63 once, Malak. Yes, I attended the personal hearing at your office on January 30, 2026. As we had notified Railway Board earlier, we had filed RTI application seeking documents necessary for our representation.
No, that is after that.
However,
30th January.
That is after that.
Your impugned order is of December 25.
25.
Yes, December
25. Malak.
25.
2nd December 25.
Correct.
Yes.
So 2nd December.
Malad, even assuming Malad, I had not participated. Malad, though my case is that we had not received the notice, even assuming Malad for a second Malad, Lordship will kindly consider that we had not participated. But where is the consideration of the materials before them so as to come to a finding that we should be banned? When Malad, page 89, I have.
That's why I'm telling. With regard to, they have received some charges against you, and that charges has been communicated to you on 8th of August 2025. Right. Correct. Directing you to submit your written statement within 13 days. 13 days. That is a statement of charges. And you have not submitted any reply.
Yes.
8 August. So
yes.
They have waited for 4 months. After the 4 months, they have passed the impugned order on 1st of December 2020.
Not that they have fixed any date and intimated us. Those letters are not that. That a hearing is fixed.
Not
they have just only forwarded. Well, assuming we have not given a reply, but a hearing has to be called on.
Not hearing, sir. Not hearing. Kindly come to your page number page 30.
30.
Page 30, last 2 lines. Hence, you are hereby requested to submit your written statement. Within 30 days from the date of issuance of this order.
Let us assume, my lord, it went to the correct address.
Where is the averment this has not been served to you? Where is the averment in the writ application that the notice was not served to you? That 18th March 2000, 18th August 2025 is not served to you?
I have stated. That I have stated. না 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 আমরা যে ওখানে অ্যাগ্রেসিভ যাইনি সেটা
Where is your case? You made out? Nothing.
Lordship will kindly give me a minute. আরে যেটা বলছে যশ সাহেব উত্তরটা দে। হ্যাঁ। যশ সাহেব যেটা জানতে চাই সেটা বলতে পারছি না।
Who had drafted this writ petition? Kindly come to the page 28. Page 28 is the P2.
Page 28
is the P2. Annexure P2?
Yes, P2.
Correct. Now come to the page, writ application, paragraph 5. Who has drafted the writ petition? Read, what is the P2? And you have disclosed the P2 as 18, whoever.
That the subject of the allegations in the instant dispute date backs to tender and credential verification issues recorded in the revised statement dated ATO, which in turn traces matters to 2013 verification. My lord, this was, yes, my lord, my lord, what is your lordship's query, my lord?
See, this is with the P2 is the communication by the chief electrical engineer to you by forwarding the charges against you.
Yes.
By disclosing the charges which is appearing at page 29 and 30.
Yes.
Correct.
Yes.
But what the averment you have made here?
I have made that, well, yes.
What is the averment made in the paragraph 5 of the, which is the P2?
Yes, my lord, P2, I have
And,
stated
and you
that.
see, and then copy of the revised statement of the charges dated 16th April 2025.
Yes.
How?
Yes, my lord, 16th April 2025.
Is the
The
charges.
revised charges, lordship will
Correct.
see the signature.
Correct.
And
That's
it has been forwarded by a letter dated 18/8/2025.
correct.
And it pertains to, my lord, lordship comes to page 30, page 29, my lord,
Yes.
20 revised charges
Hmm.
pertaining to tender dated 26 September 2013.
Correct.
Yes. So 26/9/13 is the tender based on which the revised charges are being made. I had offered for this, offered my bid for this tender in 2013.
So where is the first charges?
First charges, my lord, this is the revised charges on which we are relying, my lord. My lord, first charges, my lord. Yes. And they are forwarding this revised charges on 18th August.
Correct.
Pertaining to 2013. My lord, that is my averment at page 5.
But you have not given the reply also. You have not submitted any reply. What?
My lord, these are the application, these are the documents which we have got by RTI. I can show to your lordship. The RTI applications also.
RTI is RTI, sir.
Yes.
The August 2025, you received the charges. The
lordship,
charges which they have prepared on 16th of April, that one received by you on 18th of August.
Yes.
But you have not given the reply. For 4 months, the authorities have waited for that. And in December, they passed an order of the blacklisting. Where is the wrong? If you are not avail the opportunity.
my lord, we have asked for submission of the additional documents. My lord, my case.
Where is the letter that you will give the reply to the said after getting this additional document? Where is that? Where is the letter to the authority? Yes, you may be provided some time till the providing of the all documents.
That I'm showing, my lord. My lord, page 41, my lord. My lord,
Page 41 is the
page 41,
email.
my lord, is the mail, my lord. Attachment is next page. Representation against Pan India banning of business. My lord, this is letter dated, it's my lord, 13th December. 2nd December was
That is after the
after banning. After banning.
I am asking when the charge was submitted to you, where is the reply? Where you have you asked for time? There is nothing. Let the authority file reply.
Lordship will kindly bear with me, my lord. My lord, this is a 2013 incident. Lordship will kindly consider a company, my lord, which has been working with.
I appreciate, sir. It is a 13.
We have done works of more than 300 crores. So what details of each work is given, my lord.
Correct.
Today, my lord, if I am given a, my lord, lordship knows a banning is a civil death.
Correct.
My lord, the company, my lord, today, my lord, after completing this work and in course of doing works, my lord, if they are not allowed to, my lord, participate, my lord, the company will be totally.
Let the authority come. Let the authority come.
They will come, my lord. In the meantime, I limited.
How?
So that I can participate.
You have not taken the benefit by giving the reply to the charges.
My lord, even in 2015, my lord, they have said that it's a genuine document. 2015, lordship will kindly see that. The same person, the vigilance officer, he says it's a genuine.
Correct.
He says it's a genuine document.
So
Thereafter,
you could have been given the reply to the this
in
6th April.
2025.
Why you not given the reply?
After 12 years, my lord, they
Yes.
start this, my lord. Lordship
This
will
could
kindly
find
consider
that-
one judgment on non-speaking order.
I know that's why non-speaking order what? You have been given an opportunity giving the total charge details to you. You have not given any reply. If you have not complied with the provision, can the court give the non-speaking order? What the speak? How you can say the non-speaking order?
Yes.
How
Lordship,
you can say the non-speaking order? Kindly
Lordship
come
will
to the
kindly,
order.
Lordship will kindly consider. Lordship
Kindly come to the order. The authority category is with reference to the memorandum of statement of imputation, classification form was not received, and East Coast Railway by letter so has considered the matter and informed that no response has been. So if you are not given the response, what the reason is to be given?
They
They
have
have to
one,
record.
1 minute, my lord. My lord, 1 minute, my lord. My lord, Lordship had seen they had themselves addressed letters to the Army Department.
Sir,
Army
you
had-
want the total merit? Then I have to pass on merit. If you want that, let they file the report. I will fix it then on the next month. Then let they come, because I am not satisfied with that. If you want that on the interim order, you want on fact, then I will dispose of the matter on fact.
My lord, that order was what your lordship is, my lord, proposing to pass, my lord. Maybe
Let them file the report.
But there is one
Let the
alternative
explain-
suggestion. My lord, can it be?
I appreciate with regard to 2013. If you could have been given the reply and they have not considered your reply, your case is in the high
My lord, can
value.
it be set
But
back?
here you have received the charges, you have not given the reply, authority waited 4 months time, you have not given any reply, then the authority has nothing to do but to pass an order. So, and that's why
Can it
now
be-
the authority has to come, let they satisfy this court with regard to the 2013
My lord, my lord,
incidents,
they had-
whether the
my lord, they had asked for a personal hearing. Can it be sent back for a personal hearing, my lord?
let they come. This court find that the matter is to be heard on the presence of the authorities as well as affairs on the authority in spite of the service of this notice for the interest justice case is adjourned. Let the matter appear on 12th of June 2026. The authorities are directed to file the report by way of an affidavit after serving the copy to the land council for the petition within 2 weeks. Exception to the report if within 2 weeks thereafter. List the matter on 12th under the same heading. The petition is directed to communicate this order to the respondents and to file affidavit of service on the next date.
It will appear in the same.
Yes, lordship. Come on that day. Let they explain with regard to the delay, then we'll see to that. Next, call the that. अरे 109 कौन सा है? फाइल नहीं है?
But I'm deeply obliged, my lord, for the accommodation, my lord, and I'm equally grateful to my dear friends, my lord. Page 28, my lord.
You have an extra copy?
Yes, yes. Extra copy. My lord, page 28, annexure D. Page 28, my lord, annexure D.
Yes.
It's Japan, my lord, 13-8. And my lord, the earlier order passed by your lordship, my lord, rather the last order, Koei, his brother, my lord, page 49. He is traveling for the first time, my lord, subject to correction by you.
49.
Page 49, my lord. This was the brother of the present petitioner, my lord.
Yes. Where is the communication? Why you are going
My lord, page, my lord, 26, my lord. Letter of invitation, my lord. And 27, my lord. And my lord, the invitation at page 25, annexure A. Matter the fixed.
Yes. How you got this letter? There's no mail, nothing.
There is a mail, my lord. It's
Where is the
page
mail?
27, my lord.
This time it is there. Mail is there. This time at page 27.
27.
Yes.
We all have become expert in these matters, my lord. So this time the mail is here at page 27. But it's a long time.
So that's why you persons are appearing in the criminal matter cross-examination. So the advocates who are in the defense side, keep note what is the cross-examination during, so that
Next time it can be.
Next time it cannot be.
Yes.
Only thing is I can point out that the time period given, that the letter, invitation, visa permission all shows that yes, he has been invited for an meeting at Fujisoft. But the time period, if your lordship take page 20, 26, 25.
25, yes.
Second paragraph, first sentence. Mr. Kanodia is scheduled to visit our office in Japan towards the end of May or early June. So it's a one visit. I believe that won't take more than, it may take few days time. Then the fourth paragraph, he will bear his own cost for travel and stay. I don't mind for that. But they are seeking for a time from your lordship from 13th May to 8th of June, which is almost 1 month. At least 25 days.
No,
So if it can be shortened.
Japan is a big country, so it requires some time.
That is why, that is what I only indicated. I leave it to your lordship. I only indicated this, that this is a big time they are asking
Yes,
for.
what you will do 1 month?
It's not 1 month, less than
25 days.
It is end of May to early June.
Early June.
Come.
Page 25.
Each malad will come back, malad, and will report, malad. And the main matters, malad, are fixed, malad. Okay. But it was the end of June before your lordship, malad. I just give that exact date, malad. Malad, nothing is going to happen before that, malad. And for this petitioner, malad, this is the first time, malad. He had never availed this opportunity in last 6 years, malad. It's just for malad.
6 years কেন? 6 বছর আছে।
কত বছর আমরা জানি? 6 years, 6 years. He has never traveled in last 6 years, malad.
এতদিন পরে, after so many days, if he travels
So
for
there is
so many days,
there is a genuine reason, malad.
for so many days, he's also a senior citizen.
And malad, the matter fixed before your lordship is on 11th of June, malad.
11th.
So prior to that, malad, he's
Before
coming.
1 week is required because you will hold the
Malad, 8th,
conference.
malad, he's coming back, malad. We'll come prepared, malad.
1 week before, because you can hold the conference.
Right,
also.
but we'll do that, malad. We'll come ready, malad, on 8th. We will not embarrass your lordship on 11th. Most obliged, malad.
Yes, first. The petitioner has filed the present application praying for permission to allow the petitioner to travel from India within bracket Kolkata to Japan on 13th of May 2026 and to return from Japan to India within bracket Kolkata on 8th of June 2026. The petitioner submits that the petitioner has received an intimation on 28th of April 2026 from the company Fujisoft, Fujisoft, to attend to participate in the business meeting at Japan, which is scheduled to be held in the end of May and early June 2020. In the end of month of May 2026 to early in the month of June 2026. On the basis of the police of the petition submitted, the petitioner had to attend the said meeting, and as such, the petitioner requires permission from this court to go to Japan to attend the meeting. The learned counsel appearing for the respondent authorities, enforcement directors, and you are appearing
as well as not
enforcement director and the Union of India.
Joint Director, Minister of Corporate Affairs.
And the Union of India.
He is appearing.
Union of India. I'm for the Bank Authority. And the Bank Authority. And the Bank Authority submits that the petitioner intend to go for the meeting about 1 month. 1 month. The same is not reflected in the invitation dated 28th of April 2026. 2026. Full stop. At the London Council for the respective parties peruse the materials on record. This could find that the petitioner has received an invitation on 28th of April 2026 to attend the business meeting at Japan, which is scheduled to be held in the last week of May 2026 to the early June 2026. Early June 2026. Accordingly, for the interest of justice, the petitioner is permitted to travel from Kolkata, India, within Calcutta to Japan on 13th of May 2026, and to return India within Kolkata on
8th of June, page 20.
On 8. No, come early. Come 1st June.
Tickets,
Ticket is not a
because
problem.
matter so far the co-accused persons are concerned, is on 11th.
It is not a problem.
Come first.
8, he will report, and first time he is going,
8th June.
most obliged,
8th
most
June
obliged.
2026. Full stop. Before leaving the country, the petitioner shall appear before the enforcement director and will submit his flight tickets and invitation letters on or before. So tomorrow you are leaving.
But it's 13th,
13th.
On or before 12th of May 2026, and will submit the flight tickets and invitation letter before the concerned authority. The enforcement director and the Bureau of Immigration shall inform about the petitioner's itinerary, disclosing the date of travel of his and his date of travel, its activities, and the date of return. The Bureau of Immigration shall forward the undertaking of the petitioner to the airport authority so that the petitioner may not be detained at the airport or face any problem. Full stop. With the above direction, can number so and so.
It's 1, can 1. Most obliged, most obliged.
But we have intervening vacations during this time. Mr. Bhattacharya may go with as a legal advisor. Mr.
The way
Bhattacharya
he
should
is
be there.
opposing, even I cannot roll.
No, that's why he had kept the 8, so he will leave on 24.
Yes, so that he can be their legal advisor over there.
8, so he will back
And I'm
with
sure,
8.
my landed
So
friend will not join
two
issue,
days-
if I
two days
file
will
a
be
similar
adjusted.
application. And my landed friend will not join issue if I file a similar application.
If you bring good chocolates.
When
So-
the main matter is fixed on?
But 11th. So for the co-accused persons.
10 is disposed.
Item 21, Your Lordship. It's a matter of extreme urgency, Your Lordship.
Item number?
Your Lordship. Item 22, Your Lordship.
22.
Your Lordship has instructed ROC to take instruction twice, Your Lordship, for approval of DIR 12, which was filed subsequent to removal of minority director, Your Lordship. Your Lordship may kindly come to 22.
The respondents are not here. How the matter can be taken up?
Your Lordship, it's a matter of great urgency, Your Lordship. They are
But nobody's here.
Your Lordship, on the last occasion also, they have taken a chance to take instructions from the ROC, and now they are not present.
What can be done? Yes, next.
Then my lord, kindly fix any date.
Your Lordship, any date, Your Lordship.
Kindly, my lord.
It will remain in the list. Come on that day.
Any date on the next month.
Huh?
Your Lordship, the entire business is jeopardized.
Record 22 record. None appears on behalf of the respondent. For the interest of justice, the case is adjourned. Let the matter appear on 16 June under the same heading. Yes, next 23.
And kindly take trouble to look at my lord, page 23.
Who are the respondents?
My lord, the fire brigade
State, there
department,
is,
my lord.
huh?
Fire brigade, my lord, I am asking for very innocuous order.
What innocuous order?
We have applied for the fire license.
Ah.
My lord, kindly look at my lord, page 23.
Ah.
They have, my lord, written that fire license has been issued. Kindly look at my lord, page 23.
Page 23.
23.
Demand notice for issuance of fire license.
In pursuance to the reference of fire license, my lord, your fire license will be issued. Then, my lord, what license was issued, my lord? Next page.
What license?
Only, my lord, regarding certain articles, my lord, they have granted license. We have again applied for. My lord, that applications, my lord, did not consider. My innocuous prayer is, my lord, kindly direct the fire license department to consider my application.
Where is your application?
My lord, last application, my lord, I have made, my lord, that is at page 46.
What business you are running?
My lord, nursing home, my lord, I have got.
Nursing home?
My lord. 2-floor, my lord, in a local area, Shalkia, Howrah, where, my lord, the downtrodden sections are being treated. I have got, my lord, the clinical certificate license, my lord, till 27. But only, my lord, fire license certificate is required. We have set up the fire equipments, but whether these are adequate or inadequate, my lord, that has to be scrutinized by the fire department. If, my lord, is inadequate, my lord, kindly direct them to provide all the, my lord, the fire prevention equipment at my cost. This is my humble prayer, my lord.
The petitioner is running a nursing center under the name and style of Bansal Nursing Center at premises number 20 Dobson Road, PS Golabari District, Howrah. The petitioner has applied for grant of fire license before the concerned authority, before the home, before the department, before whom you have applied?
Before the department, my lord, the fire brigade, government of West Bengal.
Before the concerned
Respondent
authority,
number,
before the
respondent
concerned
number
authority
4, my lord.
on 4th of October 2025.
Oh, respondent number 2-4, my lord.
But in spite of receipt of the said representation, till date, the authorities have not provided the fire license to the petitioner. Counsel for the petitioner submitted the petitioner would be satisfied if the petition is disposed of by directing the respondent number
2 and 3, my lord.
Respondent number 2 and 3 for consideration of his representation dated 4th of October 2025 for issuance of the fire license. Considering the submission made by the counsel for the petitioner, this court find that the petitioner already made a representation to the concerned authority for grant of fire license for running the business of nursing center under the name and style of Bansal Nursing Center. Accordingly, the respondent number 2 and 3 are directed to consider the representation submitted by the petitioner for grant of fire license after giving the opportunity of hearing to the petitioner and to pass a reason in his speaking order within a period of 4 weeks from the date of receipt of this.
If your lordship direct them to provide, if there is any inadequacy, my lord, with regard to fire,
Giving an opportunity.
They will provide, my lord, at my cost. They are, my lord, licensed fire.
Giving an opportunity of hearing to the petitioner to pass a reason in speaking order. If at the time of inquiry, at the time of hearing, if the authorities find that the petitioner is required to comply some other provision, the authority can provide sufficient time to the petitioner for complying with all the provisions for grant of fire.
Madam, obliged to your lordship.
Any interim order?
Items number 73, my lord, my interim order is expiring tomorrow. I'm mentioning upon notice.
Tomorrow?
My lord?
Tomorrow?
Tomorrow, my lord.
Item number?
73.
Though the matter is appeared as item number 73 in the today's list, but due to paucity of time, the matter could not be taken up for hearing. It's that interim order is still today and paid for extension of interim order till 9th of May 2026. And paid for extension of interim order. In view of the submission made by the counsel for the petitioner, the interim order is extended till 29th of June 2026 or until further order, whichever is early, let the matter remain in the list. Yes. Yes.
My lord, may I have my lordship's leave to mention that matter fixed on 12th at my lord 3 p.m. Lord, we came to know that my lord, upon notice, that lordship is going off for a circuit bench. My lord,
Which matter?
that matter with regard to the senior account. Yes, my lord. I had a word with Mr. Mithro. I'm heard that lordship is coming back on 22nd. I am. You were surprised, my lord. Anyhow, my lord, lordship is going for a circuit
I am also
bench.
after. I am only one court who is going after one
year. Obviously, my lord.
We also came to know yes.
Yes.
After 1 year, I am going. Otherwise, all the judges are getting.
And is it the place where lordship?
No, I am going Jalpaiguri.
Then it is all right, my lord. This is a nice time to go, my lord. In any event, my lord, lordship knows that this was fixed after a lot of hardships on 3 o'clock. Any day after reopening, lordship fixes it, my lord. I'll inform Mr. Mithro also. my lord. At 3 o'clock, my lord.
9 जुलाई नहीं जून में कुछ नहीं है कोई खाली है फर्स्ट कब है
This was suddenly, my lord, fixed.
Actually, it was November, but shortage of judges. Then
this is a nice time to visit that place, my lord. Pre-vacation, nothing like it.
I have no vacation in there also. Huh?
3 p.m.
23rd June.
Very well, my lord. At 3 p.m. at least, my lord.
3:45.
Well, any day 3 p.m., my lord. 3:45 is too risky, my lord.
3 p.m. then it will go July.
Be that as it may, my lord, gives me a date in July itself, my lord. I hope lordship is not going
July.
then.
9th July.
9 July, my lord, at 3 p.m., my lord. Grateful. I'll inform
What
Mr.
is the number?
My lord, I'll give it.
Yeah, you record it. Record though. Though the matter is fixed on, no, ये तो list में वो नहीं होगा ना. 9 July कर दो 3 p.m.
Grateful, my lord. I'll inform.
It's not listed, it will not.
No, my lord, it will come on 12th. It was fixed. Grateful, my lord. Deep.
May I have your lordship's kind leave to mention a matter, my lord? I had mentioned this yesterday, my lord. But I had wrongly given my lord's court officer as item number 152 instead of 159 of your lordship's monthly list. My lord has fixed it on 30th June at 3:45, my lord.
What is the number?
My WPO 159 of 2026, item number 159 of your lordship's monthly list.
Order, what can be done? My order is already uploaded.
Only thing, but I was not appearing for the.
Then you have to call the review application, recalling application.
I am not even part of that matter, man. That is the only thing.
So what can be done? Okay, you come on that.
I am for the petitioner.
On that date, my lord, it is a different matter which may have been disposed of, which may be disposed of prior there to my lord.
I came to know from the case status.
Okay, you. So एक काम करो, उसका साथ वो वाला number भी रख दो. Make sure this will not be taken. That matter will be taken. उसका.
Grateful.
My lord, I want to mention a matter, item number 48, appearing in person.
Unmute. Sir, you have been muted. You unmute your microphone.
I am mentioning item number 48.
Yes.
To fix the hearing. It was supposed to be fixed in 28th February, but due to that any reason not come. Any day on after opening, connected with the resolution plan.
Okay, you come on reopening day, you come, we'll see to that. You come.
My lord, fixed today. I am cancer patient. I cannot appear day to day. Any day of July, 3 p.m. any day.
Item number?
48.
Item number 48 record.
Any day.
The petition is appearing in person through virtual mode and he prays for fixing any specific date and time. Accordingly, let the matter appear on 14th of July at 3 p.m.
Okay. Highly obliged, my lord.
Your lordship's leave, my lord, this is specially assigned contempt matter. And my lord, I cannot go before the other bench. My lord, the interim order is expiring on 15th of May. I'm mentioning upon notice.
18th May.
15th May. Lordship last order had ended 2nd April and the matter was due to appear on 12th May. We also came to know yesterday only that Lordship's bench is not available. Well, I was also not in.
17th April.
17th.
Acha, extended till 15th May.
15th May and that.
Who is for the other side?
Madam, we have informed, I am mentioning upon notice. Notice has been
But it is not listed, no?
Not listed, but we could not
How it will be uploaded? It can be uploaded.
maybe treated as on the days list, my lord.
Huh? How it will be uploaded?
Poison side, lordship. Poison side, or maybe treated as on the days list.
एक list कर देना इसको. The petitioner, though the matter is not listed today, but the counsel for the petitioner mentioned the matter and prayed for extension of interim order. He submitted that the interim order is till 15th of May 2022 and prayed for extension of interim order. In view of the submission made by the counsel for the petitioner, the interim order is extended till 30th June 2026 or until further order, whichever is earlier. Let the matter remain in the list and let the matter be appear. It was 12th May. What has happened on 12th May?
12th May is 12th May. No, that is on Tuesday, coming week. Lordship will not be there. I also got confused.
Let the matter appear on. Let the matter appear on 11th June.
June. My lord, great. My lord, with regard to item number 30 of the today's list, my lord, the petitioner does not want to proceed with the matter, my lord.
Which one?
Item number 30.
30.
30.
Ah.
That the petitioner
You have got instruction?
Not instruction. I have not got the written instruction on my hand, my lord. But there was the challenge was with regard to the non-issuance of the passport, renewal of the passport. Since the criminal proceeding was pending, my lord, we had placed two judgments of the recent Supreme Court Judge Mr. Chopra. That was leading me in this matter, my lord. My lord's view was that you have to quash the proceedings either before the criminal court.
Go to the criminal court.
It has been quashed, my lord. The coordinate bench of this court has quashed the proceedings, my lord. If he wants to renew the passport, apply for afresh, the writ petition would stand as an embargo for. That's why he doesn't want to proceed with the writ petition. My lord, turns to the last page of the order. Judgment.
Achha, but the proceeding quashed.
The entire proceeding has been quashed, my lord.
Record item number 30.
30.
Item number 30, learned counsel for the petitioner submits that in view of the judgment passed by the coordinate bench of this court in CRR number 364 of 2023 within bracket Tapendranath Banerjee, Tapendranath Banerjee versus State of West Bengal, dated 22nd of April 2026. The WPO 870 na? WPO number 872 of 2025 is become infectious. In view of the above, the writ petition is dismissed as withdrawn as infectious.
I'm grateful.
Your Lordship, may I be pleased to mention a matter for upgradation? It is appearing in.
Come, June. Upgradation June now.
My interim order have expired, my lord.
When?
Yesterday, my lord, I have mentioned it, my lord, I'm mentioning upon notice.
Yesterday? Oh, yes, na.
May I have your lordship? Order was not uploaded, so my lord, I thought it.
And may I have your lordship leave to mention item 5. It may not reach today, my lord. This is the matter, your lordship, heard the matter for 5 days. Mr. Supratim Dhar is appearing for the state. Perhaps they are not appearing, my lord, in view of the change of ruling dispensation. Your lordship, I am told, my lord, this court may not be available for some time. If your lordship kindly treat this matter as hard in part, my lord,
Come on then. Let after vacation you come. We'll.
Your lordship heard the matter. Only they are supposed to deliver.
Come on.
Sides of judgment.
Let the matter remain in the list. I will take the matter. Yes, call the matter.
না 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 প্রয়োজন না।
প্রেম জ্ঞানী।
But I'm almost done. Some follow-up questions are there in case. Shown question 232. Are you in a position to produce the death certificate of your father today?
I think it's given.
আচ্ছা দেখান কোশ্চেনটা দেখান কি আছে
232.
Death certificate of the father. I have the death certificate, but there is an error. Maybe the next day I'll produce it, sir.
I am suggesting to you that notwithstanding repeated opportunities, you are deliberately not producing the death certificate.
No, sir.
Are
I
you
do
in
not
a
agree.
position produce the shown question 240 and 241. Are you in a position to produce the deed of partnership dated 30th May 1991?
No, this was being handled by my brother, like I said.
No, this was being handled by my brother.
And I looked in the files, we couldn't find this particular document.
But
We
I
looked into
couldn't-
the files, couldn't find this document.
I am suggesting to you that you are deliberately not producing a copy of the deed of partnership dated 30th May 1991 because the same, if produced, would demonstrate that you have deposed falsely before this honorable court.
I disagree, sir.
Shown question 287.
287 or 267? I'm sorry, 267. 266 and 267. Are you in a position to produce any application or letter which you had made to the Kolkata Municipal Corporation?
Yes, we have produced one letter that we made to the corporation.
Yes, I have filed one application which has been submitted to the municipal.
And it is there in the submission. Yes.
Can you identify which document you have in mind from the judge's brief? Shown judge's brief.
क्या हुआ? कहाँ में? कहाँ पे? रुपये में? ठीक, ठीक, ठीक।
This is a copy of the letter which is sent to the police station. There's a letter that is also given.
Just tell the page number, that's all.
No, this page number 93 is here. This is to the Park Street Police Station. There is a letter to the corporation also.
According to you,
Can't locate it here.
I can't locate it again. I can't locate. Now, are you referring to this or are you not? I can't locate it or?
Yes, I can't locate it here.
Well, the answer is I can't locate it. Then I am not asking. Shown question 248.
No, document.
Are you in a position to produce the letter dated 4th October 2004 today?
That letter was submitted, I think, but I can't locate it. It should be there. That letter has been submitted.
Give him the judge's brief, let him locate it. Please identify the letter from the judge's brief.
I can't locate it here. But there is an order from KMC that is
Please
here.
answer the question.
Yeah. There is a letter. If needed, it will be submitted. नहीं वो है नहीं यहाँ मैं नहीं
I am suggesting to you that you are unable to locate any of these letters because the same has been deliberately suppressed by you.
I disagree, sir.
I am further suggesting to you that the letters, if produced by you, would show that Calcutta Carpets, being the partnership firm, was all along a tenant under the plaintiff and has suppressed the running of the company.
No.
Well, that's all.
Any witness? Close. Defendant witness number 1 is present. Cross-examination resumed and concluded. Counsel for the defendant submit that the defendant will not adduce any further evidence. According evidence is closed. This is the matter. On give the date for argument.
Then I think between us we'll finish in one day.
Yes, yes.
10th July at 3 p.m. for argument.
10th July.
10th July 3 p.m.
3 p.m. Obliged. Your Lord.
না না ঠিক আমার কিছু নেই I think by 4:30 we'll both finish.
Better. Which year suit it is? 22.
22. No, it started hearing this year. Lordship started hearing this year, but short issue, so we'll finish.
Yes.
কিছু বলারই নেই.
Consent to a decree now. I will consent.
I told him you've got nothing to say, so that's why I said we'll finish.
I'm saying you consent to a decree now, then my lord can pass it here. Decree by consent.